ಕೋರ್ಟ್ ಆಫೀಸರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ತಗೊಳ್ತಾರಾ?
Lordship's kind leave, my lord. My lord, this matter pertains to a land grabbing court, my lords. After a suit has been dismissed and an appeal has also been dismissed on the same cause of action, the complainant has initiated this proceedings, my lord. The petitioners are old and are senior citizens, my lord. It is posted for tomorrow for framing of charges, but the matter may be taken up at the convenience of this honorable court, my lords.
We'll have it next week.
Much
We had
obliged.
one,
Much obliged.
This matter relates to Justice Keshav and Committee's report, my lord.
Pardon?
This matter relates to Justice Keshav and Committee's report, my lord. The land is now notified for acquisition. My development work is getting stalled, my lord.
Is it a fresh writ petition?
No, it's already listed, my lord.
When is the date listed?
No date is given so far.
You get it listed, na? Your writ petition.
Yes, my lord.
Remove the objections.
The objection is already filed on record, my lord.
Okay,
Check with
show
the
us
officer.
that.
Lord, with your lordship's kind leave,
Just
What?
one.
one PAL,
One minute, please. This is writ petition of Just see you next week and we need to.
My lord, this matter pertains to my lord.
Yes, one. Yes.
that one PAL matter pertaining to quotal number one, my lord. In this, my lord, I challenge the reservation provided in the tender matter, my lord. Outsourcing agencies have been directed to provide tender. Directed to take employment on the roster basis, my lord. In the tender matter, my lord. I have challenged that notification, my lord. My lord, it is filed about 1 month back, my lord. Now the final, if they finalize the tender, my lord, this becomes infructuous, my lord.
When are they finalizing?
My lord, it is scheduled for 23rd of this month, my lord.
We have it tomorrow. 23rd.
Yes, my lord.
What is 23rd?
Monday.
Just have it tomorrow.
Much.
For day after tomorrow, anything day after tomorrow.
Much obliged.
The 20th.
20th. Much obliged.
Yes.
My lord, the issue pertains to the state government directing the district mineral fund, my lords of the Bellary, to transfer a huge sums of money to the newly constituted Vijayanagar, my lord, which is illegal. My lord.
What is the nature of petition you have filed?
I filed the PIL, my lord, but it is now classified by the office as GM MMS, my lord. I need, because it's filed in July 2024, but it's not been posted. But the
We'll
direct-
move tomorrow before the roster bench. Okay?
Fresh matter, no. Any date may be given, please.
Tomorrow, move the roster bench tomorrow. Okay?
No, this is with respect to the mines, not mines matter. They have imposed fine as against the
So
petition.
you have to move the roster bench tomorrow. Move tomorrow.
Electricity matter, it is disconnected yesterday, my lord. The tariff order was LT2 to LT3, they changed, they imposed penalty unnecessary.
What is the nature of petition you have filed?
That is appeal is filed against the judgment of the learners in the
This would be, is it 24? This would be chief court, no?
tomorrow,
GMT.
total one.
Yes, 1 minute. Court hall 1, na?
Total one.
You mention it tomorrow before the Honorable the Chief Justice. Better would be that.
Lordship, matter pertains to land grabbing issue, Your Honor. The complaint has been challenged before this honorable court, stating
The
that
pending matter?
it's a fresh matter. Lordship.
Okay.
It's a matter wherein the impugn complaint is challenged before this honorable court, wherein they allege that there is a grab of 32,000 square foot of government land. Where
Are you challenging?
the complaint and the order passed by the land grabbing court, wherein subsequently the land grabbing court has issued a notice to the revenue authority to conduct a survey on matter is coming up on.
Is there, then where is the grievance? They will conduct a survey, the report will come.
The only thing is there is no such government land existing in the petitioner's land, Your Honor. And already survey was conducted prior to.
Not, we will list it. We don't say anything. It's no, there is no urgency in this matter.
The only submission, Your Honor, one submission, because there was already survey conducted by the concerned authorities, Your Honor, and there was also a report filed, which was not to.
Just give it next week.
Your Honor,
Your Lordship,
WA 983 of 2024, I am the petitioner and party in person, appellant and party in person. The WA was posted for orders.
Where is the petition listed?
It was listed on 21/8/24.
Which
and
court?
Again, in this honorable court,
Which
on-
court? 1 or 2?
it was posted for orders by Court Hall 1
Yes.
on 21/8 and also again here on 9/9/2024. And I expected the orders to be granted for the interim relief because the Honorable Court has already recognized the breach of Patent Cooperation Treaty and have issued orders, and according to annexure,
What is the next date of hearing?
it has been, without granting the interim relief, it has been posted for 24/10, Your Honor. I need it to be posted today and so that I receive the interim relief
The better
orders.
would be, what is your good name?
Srinivas S. Devati.
Mr. Srinivas, do one thing. Tomorrow the court one is sitting. You mention it before court one and get your this thing listed tomorrow. Okay?
Is it possible to have this heard today and then
No,
grant the
not
orders?
possible, not possible. Mention it tomorrow before the honorable.
What are the Honorable Chief Justices?
That's right. Expected. You mention it before that.
Okay, I have to check the cause list then.
Yes, yes, do that tomorrow. Yes, ma'am.
The petition has been filed seeking a writ of mandamus as against the state commission since the matter has been posted for orders.
Against what?
The state commission, the matter has been posted for orders since the past 2 years. However, orders.
They have reserved it for orders for 2 years.
Been reserved for orders for the past 2
Could be
years.
ours.
Consumer.
Just have it listed.
That's one matter, let's contempt.
Yes, one.
I'm sorry.
Yes. Just listed next week. We'll have it next week.
Much.
One
Yes.
matter on contempt, please, my lords. What transpires is I was a successful auction purchaser of a BDA site. BDA site, please, my lords, I was the successful auction purchaser. I made good the entire consideration. The BDA thereafter, after 6 months, told me, please, my lord, they cannot execute the sale deed for the reason that the auction site was already sold in an earlier auction. Now, my lords, I requested them to pay me back my monies which I had paid. They did not pay. I came up before a learned single judge, the Honorable Court. 2 months' time was given to the BDA to make good the amounts. The BDA did not make good the amounts. Then thereafter,
You
then
have
I
filed a contempt now?
I have filed a contempt. They paid only the principal. The interest, my lords, component, which is directed, my lords, by the learned single judge to be paid.
That not paid.
Not paid. I have already paid the bank.
What do you want now?
Let's say to frame charges, my lords. Otherwise, the BDA will go scot free.
Pardon?
To frame charges against the BDA for deliberate, my lords.
Where is the contempt listed?
Lords, it is listed, my lords, before Court Hall 1. May I request, my lords, for next week?
Where is when is the date? In the
There is no
contempt?
date given, please, my lord. That's the issue.
No, are you moving this?
Yes,
Do
my lord.
one thing, move tomorrow before the court one. Better would be that. Okay? All the list.
List number 2, serial number 1. List 2, serial number 1.
Let's see. Yes, we notify.
411. Serial number 2, Shri Shreya Kumar.
We notify.
411. Serial number 3, Shri Ravindranath.
We notify.
Already, party will not complain.
511. Serial number 4, party in person, Shri Naveen Jaikar. 511. Serial number 5, Shri Gopal Krishnamurthy.
In this matter, I am for the petitioners. I am filing memo for withdrawal petition with the liberty to.
We'll have it day after tomorrow. We notify.
20th September. Serial number 6.
My lord, I pray for 4 weeks' time to complete.
We notify.
1211. Serial number 7, Shri Vivekananda.
We notify.
If calling.
10. Serial number 8.
My lords, make a petitioner kindly have it on 25th, my lords.
Which
25th.
matter?
8, my lords. Serial number 8, portal number 1.
We notify.
25-9. Serial number
Grateful.
9. Shri Chikkanagowdar.
We notify.
Your Lordship, appearing for the
20.
complainant, kindly 2 weeks' time may be given for the compliance.
Just,
22-10.
yes.
Serial
next.
number 10, Shri Siddesh.
My lords, I appear for accusations. Undertaking to file
Notify.
Wakalat.
23-10. Serial number 11, Shri Swami.
I appeal to the complaint, my lord.
We notify.
23-10. 12, Shri Yeshu Baba. For the complaint.
We notify.
23-10. Serial number 13,
We notify.
28-10.
14, we notify.
14, 29-10, 15,
We
Srimati Ashwini, 30th October, 16, Suresh,
Complainant, my lord.
24-10,
This is the BBMP have filed this thing. They have taken 2-3 adjournments to file the affidavit. They have not filed.
In
Actually,
item 16,
yeah, 16.
who appears 16? Why no
Oh, this time-
response file?
call commissioner for this thing, my lord. They have not taken any responsibility. In the year 1992, they have.
What is the order alleged?
Actually, they have taken my property for construction of wall to the river in Bangalore. It is in the year 1992. On the date from here, they have not given the alternative site. So this is the problem, my lord. This order passed by this honorable court,
Yes,
1 year
yes.
and 6 months old. Kindly please order
Sir,
commissioner to.
24/9, sir.
Next.
Serial number 17.
Your Lordships, I'm appearing for the appellant in this matter. Notice has been issued to the respondent.
Pardon?
I appear for the appellant in this matter.
Yes,
Notice has been issued to the respondents. my lords.
notify.
11th of November. 18, Shri Ganesh Rao.
My lord, the name of the accused number 3 has been wrongly mentioned as Rajiv Kumar instead of Ranjiv Kumar. I filed an application for amendment. My lord.
Just re-notify. You have filed an application, huh?
Application for amendment.
Okay, re-notify.
Kindly allow.
30th September.
The others are there, other officers.
Other officer 2 or
Who is the officer who has to implement it?
that
He
accused
should be
number.
there, that's all.
Yes, my lord. He is not.
Five from top to bottom, everyone. Swipe you, let's see.
30th
Re-notify.
September, sir.
My lord, some inconvenient, some after vacation it may be
Yeah, we'll have.
15/10, sir.
Huh?
15/10.
15/10.
Serial number 19. Shri Subramanya Bhatt.
20, re-notify.
24/10. Serial number 20. Shri G.R.
Lordship, in
Mohan.
this matter, it was listed last week also, again urgent today. The matter pertained to the fencing of the lake, which was about 72 acres.
We'll have it tomorrow.
Now they have removed the fence. They admit in their affidavit also.
Yes.
My only request is because punishing the chief commissioner doesn't know well, let them fully fence that area and preserve it, your lordship.
Just
That is the only thing I request so that they can do it. I filed my rejoinder also. On 100 feet road, they have formed, your lordship.
Sir,
Short
30th
date
Sep-
maybe, so that only direction, lordship may
Sir, 30th
let them
September.
think over and fence the lake. Your lordship.
30th September, sir.
30th September.
And in meanwhile, let them just fence it at least, your lordship, so that
Tell us one thing.
they
are we-
admit,
They have an obligation. Are we required to tell them?
please,
They should know. Come on, 30th.
please, your lordship.
21, Srimati Rupa Shri.
Re-notify,
28/10. 22, Shri Mukanappa.
re-notify.
29/10. 23,
I appear for the complainant, my lords. It may be kindly had on 26/9.
What is the urgency?
The urgency is that, my lords, the accused is the investigating officer. FIR was stayed despite that charge sheet has been filed. Therefore, my lords, the FIR was stayed on 10,
Next week, just give it next week. Re-notify.
26/9. if it's
26/9.
Grateful.
24, Shri Ganesh Gowda.
For the complainant, my lords.
Re-notify,
Except an early date may
Six.
fix.
re-notify,
30th/9. 25, Shri Murugesh Charatti.
re-notify.
19/11. 26,
Re-notify.
Kapil Dikshit.
Petition. Any short date, lots.
Just see, just give it.
30th September.
Obliged.
27, Shri Srinivasan.
Apply for the complainant, my lord. A2 is served, my lord. A1, we have to take steps, my lord.
Just take steps to serve A1.
A2 have to give a reply, my lord. They have to pay gratuity to us. It's only with regard to the gratuity, my lord. More than 2 decades have
Who
passed. my
appears
lord.
for A2 here?
Served and unrepresented.
Served. You appear? Okay. But you get it listed 28. Just give it 8.
14/10.
Much-
Serial number 28, Shri Babu Rao.
Maybe dropped, my lord. In the higher level, they have passed the order. In the lower level, they are not
Just
passed.
re-notify
Subject
next
to
week.
it may be.
20th September.
Next.
29, party in person.
So, re-notify.
30th September. 30, Shri K.
Lord, this is ordered December 2023, tried to pay the arrears, and they have not paid. He is 84 years old, the
Lord,
petitioner.
I appear for the respondent one, my lord. We have filed a writ appeal. may be tagged along with this, my lord.
What is the date?
Any date which is.
What is the date in appeal?
992.
Huh?
It's not been listed yet, my lord.
Get it listed. Get it listed.
Le-
We'll give you a date, get it listed on that day.
Please, my lord.
Re-notify.
2210. Serial number 31, Shri Vasant Kumar.
Re-notify.
2410. 32, Shri Azhar Mir.
Appearing for the complainant, my lords.
Any date convenient to this honorable.
Re-notify.
28
Short
10.
date.
28 10, sir. 33. 33.
Appraise some 2 weeks time for the complainant.
23 10.
Please.
34. Shri Adinarayanappa. 23 10.
Re-notify.
35. Shri Thomas Peter.
My lord, 2 days time may be given to comply with office objections, my lord.
Re-notify. After 6 weeks.
My lord, a
20
date may be given, my lord, there is an
23:10.
urgency in the matter.
You have noted the date?
23:10, madam. 36.
Re-notify.
Short date may kindly be given, my lord.
Service is awaited.
Next.
29:10. 37. Shri K.S. Harish.
Re-notify.
15:10. 38. Shri Muni Krishna.
Re-notify.
25:10. 39. Shri Narayan Bhatt.
Notify.
4:11. 40.
Re-notify.
Complaint, my lords, in this matter, ADLR has been changed, my lords. I may permit it to.
What is ADLR?
We have already filed our complaints.
What is ADLR?
That's Assistant Director of Land Records, my lords.
Change, you file an amended memo.
Much obliged.
Notify.
110. 110, sir.
Next.
Serial number 41. Shri Arvind.
Re-notify.
110. 42. Shri Neeraj Shastri.
I beg to appear, my lords, serial number 42. My lords, we recollect, this is the same matter, my lords, which had been before your lordships a few weeks ago, where I made. I'm sorry, my lord, there's some disturbance.
Yes.
Yes, my lord. So this is the matter, my lords, your lordships may recollect, where I had brought to your lordship's attention that originally we were made to write an exam for KPCL recruitment, where we were put on notice that there's going to be negative marking. But now, my lords, when the exam was conducted recently, we were never put on notice, and post facto, we are told that there is negative marking. Now, my lords, in fact, the learned counsel of the KPCL fairly submitted on the last date that there are no steps being taken for any appointment orders. But I'm told, my lord, that there is some provisional list that has now been published. Mr. Prithvish, who is in court, my lords, may have more details. I'm sorry, I couldn't be there in
Are they
court due to.
publishing the list?
They have published the provisional list yesterday with 10 days time alerts to file their objections and
Okay.
finalize it.
We'll have it Friday or Monday.
Let me make this.
Monday.
Any short date, my lords.
Let me make this request. Now the provisional list, my lord, is published for a few disciplines. For the remaining few disciplines, my lord, it is being published today. Let my only anxiousness is this. Let your lord.
Still would be a provisional list, Mr. Pratish.
Let if the final list is published.
That's a reason to obviate that we are giving you a short date. Getting that? When do you want? Friday or Monday?
Any date convenient, your lordship.
Very
But my only apprehension is.
If you ask our convenience, we'll give appropriately.
No, may I make this request?
Huh.
Should it be on top of the list? That's my.
We will not say so. Everyone wants at the top.
Let only.
Everyone has an urgency, Mr. Pratish. So we will give on Monday.
23:09.
Much obliged, your lordships.
23:09, sir.
Mention the court on that day. If it doesn't read, mention it. Okay? Thank you.
Very well.
I'm grateful.
43. Shri Sharat Gowda.
Since in this matter, the government advocate can take notice for all the respondents, my lord. Respondents 1, 2, and 3.
Re-notify. Yes, re-notify.
15:10. 44.
Re-notify.
12:11. 45. Shri Rajaram. 12:11.
Re-notify.
46.
6, re-notify.
15:11. 47.
My lords, it pertains to the medical education, my lords.
We'll have it tomorrow.
My lords, the coordinate bench at page number 184 had granted
Have
the
it
interim
tomorrow,
order. my lords.
tomorrow. Re-notify tomorrow.
Lords, meanwhile, they may list the, announce the date for the.
We'll have it tomorrow. Okay? Tomorrow. Re-notify.
19th, serial number 48.
Re-notify tomorrow, where is the council? Re-notify on Monday. Acha, this is PI. Re-notify. Just say re-notify.
110. 40,
49.
49.
Re-notify.
For 5 and 6, my lord.
Yes.
A date may be fixed, my lord, convenient.
49, re-notify.
411.
40,
50.
re-notify.
1211.
Can it be on the 16th, my lord?
Pardon?
Can it be on the 16th, my lords?
16th.
16th,
October,
16th
just
of
give it what?
November.
16th of November holidays.
But may I request for
Sir,
7th of
19th of
November?
November.
Right. My lords, any day after vacation, my lords, because a senior advocate from Delhi is
What is the
appearing.
date?
Sir, 19th of November, sir.
All right.
Can it
19
be on-
November is post-vacation only.
Post vacation, 19th. That's all. Oblige, my lord.
Sir, may you heard on 7th of November?
Pardon?
Instead of the 19th, can it be on the 20th, item 50?
20th also is fine, my lords.
20th.
What do you want?
What senior was?
Well, instead of the 19th, I was requesting for 20th, subject to your
We'll
lordship.
accommodate 20th.
20th of
Oblige, ma'am.
November, sir.
Next,
51.
51, I appear for appellant, my lords. There is an undertaking given by the state that is recorded from time to time, that may be extended, my lords.
The matter is very urgent because, my lords, it is with respect to the establishing of the cancer hospital. Now, by virtue of the stay, we are not able to proceed with the
is
construction.
an undertaking, na, that's recorded.
Please, my
Yes, my
lords,
lords, that's a matter, my lords.
Interim, the undertaking given,
orally by the state,
undertaking as given shall continue till the next date of hearing.
Next week.
We are going by whatever you have said undertaking.
it's recorded, my lords, it's recorded.
Record, fine.
My
My
lords,
lords,
may I
next
submit?
week, the date.
Yeah, we have it next.
My lords, may I submit, my lords? I have filed the impleading application, my lords. There is an urgency for hearing, my lord.
We are having next week, ma'am.
Please, 24/9. 24/9. Serial number 52, Shri Subramanya Bhatt.
For the petition.
Re-notify 53, na, ma'am?
Sir, 52, sir.
52 re-notify.
1211. 53, Shri Arun.
My lords may kindly notify on 16th, my lord, 16th October.
Appear for respond 2 and 3.
Which one?
53, my lords.
Re-notify.
16th October.
Grateful.
54,
Re-notify.
The petitioners.
1311,
55 re-notify.
55,
Re-
1811, 56,
Re-notify.
1911, 57, 1911,
Re-notify.
58,
I appear for the appellant, my lord,
2011.
there is an interim order, my lords.
Which one?
58, my lord, serial number
Interim
58.
order, if any, to continue.
Great.
20th November.
Please.
59,
Madam,
Ye-
sir, I am 14%, sir.
Yes.
Start date, sir. 14% affected person, start date, sir.
Yes, re-notify. This 59. You are in 59.
Yeah, 59.
I appear for the appellant.
Re-notify.
There is an interim
Who
order.
is Mr. Kantaraju?
Yeah, I am counsel.
You are the counsel, na?
I am Rangachar, sir. VT Rangachar,
He-
14%.
He appears for the respondent.
Third respondent.
Respondent.
The respondent, okay, thank you. Next,
Short
Lords,
date.
there is an interim order, my lords.
Interim order may be extended.
interim order, if any, to continue.
1510, sir.
Next,
60,
Appearing for the petitioner.
Appellant, there is an interim order that may kindly.
which number?
60.2.
In
Oh,
serial,
60.2,
Yes.
in all the
all
connected matters,
either.
there is an interim order.
In all 3 matters, there is an interim.
wherever there is an interim order shall continue till the next date of hearing. 60, okay?
2910, 61, government advocate.
Re-notify,
Respond in this matter.
re-notify. 62,
2410, 62,
re-notify,
Kanapa.
63, re-notify,
30th 10, 63, 30th October,
64.
64,
I appear for the appellant. This
Yes.
matter has to be connected along with writ appeal number 817 of 2024, which has been filed by the KAD.
When is it coming for hearing? Is there any date there?
No date is.
We will just post this. Possibly you have to move a memo for tagging in that matter.
4/11/65, Shri Muttanna.
My lord, appearing for respondent number 2.
Interim order may kindly be continued, my lord.
65.
65.
I pray
Yes.
for date on 26th of this month. For
Why, what is
respondent
the
number 2.
urgency?
My lord, gratuity has been withheld from 2017. His gratuity has been withheld.
Who's his gratuity?
No, respondent number 2.
And who are you appearing for?
They are
Appear for the appellant, my lord.
That's the employer.
Yes, my lord.
We'll have it short date.
Much.
30th September. 66, Shri Narsimhan.
Renotify.
Substantially heard, some urgency in the matter, my lord. It has been heard by.
Just give a short date.
26/9,
Wait,
67,
Renotify.
7/11/68. Shri
appellant,
P. Nayak.
Appellant,
Renotify.
fresh matter.
7/11/69,
69 renotify.
11/11/70, Rakesh Kini.
Renotify.
28/10,
71.
71, Satish. 6/11/72.
72, my lord. Lord, for the petitioner, Lord, in this contempt petition, my lord, there is an urgency. The respondent is a company which is closed down without the permission of the government, my lord. Without the permission of the government, my lord. And there is an interim order by this honorable court in OSA number 8 of 2016. And there is a willful disobedience on the part of the respondents of that interim order, my lord. And the property has been alienated already. Now the urgency is that that property is, my lord, kindly have it tomorrow or day after tomorrow, my lord.
We'll just give it.
25/9, sir.
Next.
73, Shri Anand.
My lord, I appear for the appellant. I moved an application for amendment of the grounds of the appeal. So may I pray, my lord, to kindly grant any time next week, any date next week.
Renotify. Just give a convenient date.
15/10, sir.
Next.
74, Samit.
My lords, appeal from the complainant, my lords. It's a matter of contempt. The POD and the rest work has not been conducted by the accused, the Tahsildar and the ADLR for the past 2 months. A lapse of more than 3 months has been already done. Judgment has been passed somewhere in the month of June, my lords. So emergent notice may be issued.
You have filed you have not, there is no notice on this.
Lords, notice has been issued, my lords. I seek for 6 weeks' time because it is Podi and Durasti, my lords. We have to Podi and.
Why
Durasti.
6 weeks, ma'am?
My lords,
Lords,
short
Podi
time
and
with it.
Durasti takes time, my lords.
For what?
My lords, the judgment was passed.
What was the date of the judgment?
25/4/2024, my lords.
You see that you
The month
can't
of April.
exclude the past now, the period which, see, we are in almost 5 months have gone by.
Please, my lords, at least I pray for 6 weeks.
Renotify, just give it in after vacation.
24/10. 75,
Renotify.
23/9.
Great.
76, Shri Deepak.
Renotify 77.
In 77 minutes.
4/11/77.
Yes.
In the 77 is a writ petition initiated by this honorable court, and I was appointed as an amicus mirror. This is regarding the deaths of elephants, mirror. The court was shocked to notice that several elephants are dying, mirror. Therefore, a short date may be given, mirrors.
77 renotify.
110.
78 renotify. 79 renotify.
78, 11, 13.
My lords, 81 may I request?
81 renotify.
For 15/10, my lords, may I request 81?
15/10, giving.
81.
Much obliged.
Number 18, my lords.
Huh.
Education matter will be lifted tomorrow. my lords.
Tomorrow, we'll have it tomorrow.
Serial number 18.
80.
80, sir.
80.
78, 12/11, 79, 13/11.
Governmental.
My lord, serial number 2, my lord.
In
There is a
which-
special
in
bench
which-
constitute, serial number 2 in the same list, my lord. Special bench has been constituted is on 20th, my lord. Kindly, it may be posted on 20.
Pardon?
Pertaining to Shivram Karanth layout matter. Special bench has been constituted, Justice Krishna Dikshit and Justice Nagapasan.
Huh.
It is on 20th. Now it is urgent to November, my lord. There is an urgency. It may be listed on 20th.
20th?
20th of this month.
No, did
Okay.
anyone appear for the other side?
I have to serve the copy.
Ma'am,
my
you
lord.
have any,
For government.
are you appearing?
I will comply today itself. There is an urgency for demolition.
She wants an urgency, we will have it on, we say nothing. We will have it, when is the matter listed before,
20th.
before the,
Justice Krishna Dikshit and Nagaprasanna.
no, we will have it on tomorrow. You can make a request before the roster bench.
Please, please.
Tomorrow, just have it tomorrow.
Serial number 2 alla madam.
2. Obliged.
Serial number 2.
Tomorrow we'll have it.
Please. Obliged.
My lords, serial number 25, list 2, it was just. Serial number,
Which list, ma'am?
list 2, I was on my legs in another.
Which number?
Serial number 25. There's a connected writ appeal in the case. We have accepted the notice in the said case. They have challenged the writ petition order.
What is the date there?
It is connected today, it is listed today along with the contempt petition.
Madam, 1911.
That's right. We have given you a date.
If I
Just
may,
note the date.
1911.
Yes,
My lords, list number 1, serial number 27, my lords.
we'll come to the list, ma'am. Come. Yes, ma'am.
List number 1. Serial number 1. Shantesh Bhagat.
And this for the petitioner, my lord, I pray for a week's Kannada has to be
4
translated.
weeks are granted to file translation copies of the Kannada documents.
Please, ma'am.
List on.
411. Serial number 2, Srimati Shobha. Serial number 2, list 1, serial number 2.
There are 3 objections, no? Huh? 3 objections. The objections be removed within 4 weeks. Re-notify her.
411. Serial number 3, Shri Jayakar Shetty.
For the applicant. Needful done, my lord.
Respondent still unserved.
Needful done, my lord. Today, needful done, my lord.
You see. Let fresh notice be issued for service on the respondent returnable on.
1211.
Okay.
4, Joseph Anthony.
For the appellant in this matter, my lord, the
Respondent
respondent
number
number 2 is the real estate adjudicating authority. May I request for dispensing notice, my lord? I'm filing a memo to the effect, my lord.
The notice to respondent number 2 is dispensed with. A memo has been filed by the counsel for the appellant, which reads as under. The learned counsel reiterates the submission, reiterates the stand taken in the memo for dispensing with the notice to respondent number 2. It is ordered accordingly. Now, what remains in the appeal?
My lords, I'm an allottee, my lords, of an apartment. 2014 is the down payment and the booking amount which is paid. Agreement to sell is executed. Till date, the tower also has not commenced, my lord.
What has been granted to you?
My lord, I was granted reimbursement and interest, my lords, by the RERA.
Yes.
However, in an appeal filed by the developer, the order is set aside under the premise that the prayer is not maintainable, my lord. It is under a misconception of facts and law where the impugned order is passed.
By the appellate tribunal.
By the this was by the KAT, my lord, prior to constitution of the appellate tribunal.
Let's see the impugned order.
Please, ma'am. My lords, the impugned order is at page 23.
Yes.
If I may kindly read, my lords, at page 32, my lords. The Honorable Tribunal holds the admitted or undisputed, if all these are admitted or undisputed facts are taken into consideration, then it can be said that at the time of entry into contract, the intention of the second respondent was just to invest his funds and get double of the same from the appellant under buyback scheme. Therefore, we find considerable force in the contention of the appellant that the second respondent at the time of entering into the said contract was not a customer or allottee, but he was an investor or co-promoter whose intention was not to purchase an apartment, but to make profit out of his investment.
What is the basis for him to come to this conclusion? What were the facts?
My lords, in fact, if your lordships
See,
will
let's
kindly
see.
peruse para 27,
Let's see
the
the
tribunal
objection.
further, My lords, the tribunal further holds at para 27, my lords. After considering all the contentions or grounds raised by the appellant as well as the second respondent, we are of the considered view that as on date of either entering into the terms and conditions of the buyback scheme or as on date of agreement of sale or construction, second respondent was not an allottee, and whereas he was in the same position as promoter who had invested his money in the said project for getting a profit. But to the very moment when he had failed to intimate his option just 6 months prior to the date of delivery, his position became an allottee and not remained as investor. Now, my lords, the Honorable Tribunal holds that I am an allottee. I have an agreement to sell. I have a construction agreement. The developer had a scheme, my lords, called subvention scheme, under which if I've made an investment and if I don't intend to retain the apartment, I can always seek for buyback, my lords. That was the scheme. However, my prayer, my lords, is as per section 18. I have not sought for implementation of this scheme.
What had they pleaded to say that you are an investor, not an allottee?
They, my lords, that is culled out, my lords.
Did they take this plea before the earlier initial authority?
Initial authority, this was not raised, my lord. In the appellate authority, they raised this ground that I am a promoter and not an allottee.
What do you say?
Lordship, pray for time, 1 week time. To place an argument.
My lords, they repeatedly assured us of a settlement, my lords.
Pardon?
They repeatedly assured us of a settlement, my lords. Repeatedly, they undertook to settle the matter. However, every time an adjournment was granted, they never responded.
But there was a submission made by the appellant to explore a settlement.
My lords, if the previous dates are of the order perused, my lords.
Who is the counsel?
Lordship, I am for the respondent number 1. Senior is not in the administration. He has went for funeral.
Adjournment is sought on behalf of the adjournment is sought by the counsel for the respondent. Re-notify on, made clear that the matter shall not be adjourned on the next date of hearing. Just give it October, November, any date.
30th October,
Next.
Please.
serial number 5. Government ticket.
In this case, I have filed the copy. It has not been.
You have not the documents to be filed, no?
It has been filed
When
yesterday.
did you file it?
Yesterday.
Not on record?
It is not on record.
Documents stated to have been filed by the counsel appearing for?
Respondent number 1 to 4.
One. Are not on record. The learned counsel to get the
Lordship,
same
I
based
can
on.
raise the same. It's a small issue to be considered.
Very well, then we'll pass it over. Who is the counsel for the appellant?
Government ticket.
We'll just pass over. We'll just pass over. We'll come back. Next.
Document copy, my lord, it's not served on us. Your Lordship may have it tomorrow.
Just say the same, then I'm not on record, learned counsel to get the same placed on record.
Copy is also.
Copy thereof has been given to the counsel for the appellant. Re-notify on.
Thirtieth September. Serial number 6.
Is this?
My lord, there is some mistake in the order sheet. May I submit, my lord?
Which order sheet?
That is maintained by the sound, I got the printed copy.
Yes.
Last, I have filed a memo for retirement. My colleague was present last time. I don't know what submission has made, but it reads like this. Rama Bhatke, learned counsel for appellant is no more. I am still here. No more on, that's all.
We have to tender an apology. We are
Not,
very
not,
sorry.
not necessary. My God. Another advocate already appeared on record.
Mr. Bhatt, we are very sorry.
Sorry, my lord, I am also sorry.
For sometimes being represented.
It happens,
take
it
on
happens,
face value.
it happens, it happens.
No, no.
It is not intentional. I learned might have been submitted no more on record. That is not recorded.
Yes, what is the next one, Mr. Joseph Anthony?
Joseph Anthony is the advocate on record. Now, my memo of record may kindly be
Learner whose name is shown in the file shall continue as the counsel at the request of the counsel. Yes, now what do you want to say?
Now, his name is not shown. That counsel who is on record on today, not shown in the cost list.
Mr. Joseph Anthony,
It's not shown today. Not reflecting in the cost list.
does he continues to be the counsel?
That we don't know, my lord, because I have already filed retirement memo. Thereafter, he filed the wakalat.
In the last date of hearing, Milords, the council had appeared.
Oh, who?
The new council who had. appeared
Joseph,
for this.
That's right, that's the reason we will. And now
please. My name may be kindly be deleted.
maybe possibly to our recollection, I think this happened somewhere in August 28. Maybe very well. So very well. Now we take it that we note that on 28/8/2024, a representation was made in respect of Mr. Rama Bhatt K.
Yes.
Full stop. Mr. Rama Bhatt K appears in person and states that the representation was erroneous. So he also states that he continues to appear.
No, I'm not continuing. I have filed retirement memo.
So you want that to be accepted?
That has to be accepted.
Very well. So then Mr. Joseph Anthony. will come-
Continue.
That's. Mr. Rama Bhatt states that he has filed an application. Is the application on record?
Memo, retirement memo dated 26 June 2024.
Yes. States that he has filed an application.
Sorry, my memo for retirement.
Memo.
For retirement.
Retirement memo, dated 26/6/2024. Full stop. He reiterates the prayer as made in the memo that he intends to retire as the counsel for the petitioner. Counsel for the appellant.
Has already
Full stop.
engaged.
We'll stop. Noting the prayer made in the memo, the same is granted. He is permitted to retire as the
Yes.
counsel for the appellant. We find that Mr. Joseph Anthony, advocate who represented the appellant on the last date of hearing, is not present. We'll stop. Let a court notice be issued to Mr. Joseph Anthony for his appearance on the next date of hearing.
That no more than maybe deleted.
We have said erroneous, we have said erroneous, we have said, so we are conscious, we don't want to repeat the same thing.
Please, madam, please, madam.
That's the reason we say physically you are present today. We are sorry for that. No, no.
Sorry, I'm also sorry because my,
Next.
please, madam.
Yes.
2910, sir. Serial number 7.
My lords, I appear for the appellant in this matter.
Yes.
My lords, I appear for the appellant in this matter. My lords, on the last date, my lords, both parties were directed to file written submissions. My lords, my instructions are that we seek just a week's time to finalize some factual details, my lords, in the written.
Counsel for the, ma'am, you have filed your submissions?
Not on this occasion.
Counsel for the parties seeks further time of 4 weeks to file written submissions. Re-notify on.
511.
Grateful.
Serial number 8. Serial number 8.
This said 21, re-notify on 21/10.
2110. Serial number 9.
This is not the same.
And for the appellant, yes, my lordship. I filed the application for recalling the order dated on 18/4/2024.
What
In this-
happened on that day?
There is a peripheral order is there. After, within 1 week, they complained the office objection. I complained. They raised 3 more objections. So I have to, because after that, the vacation has come. So I could not able to reach.
Are there any objections today?
Today only there one objection, that is a condonation of delayed dates, days may be mentioned. I will do
Remove
it.
that.
I will do
Remove
it
that.
right now.
Why an application for recall?
There's on 18/4, there is order is.
We have seen that
condition,
order.
Condition.
Acha, sir, dismissed automatically.
Yes, please, my lordship. I complained, within a week I complained, but they raised 3 more objection. because during the vacation day, 1 month, I could not come and verify once again. So they said already time is barred, so you can't file a necessary application. So I filed a necessary application before the Honorable Court, my lordship.
We'll do one thing, you remove this objection.
Please, please.
Then we will consider it. Now, these objections were not there on 18-4.
No, not.
There was newly added objections by the registry.
One is newly added.
Only one.
One, and two more still left. Because
So then technically 18-4 has come into effect. You did not remove it.
I completed, partly I completed.
Right, but
Correct.
that was after 3 weeks.
Correct, ma'am.
So then this order will come into effect, has already come into effect.
Yes, that's why I filed the application for that, please.
But we will consider it. You remove all the objections.
Sure, please, ma'am.
We'll say something. We'll say that, just say this, learner counsel which is the application number?
EA number 1 of 24.
1 of?
24.
1 and 2 and 24. Notwithstanding the filing of the applications being 1 of 24 and 2 of 24, the learner counsel for the petitioner appellant shall remove the office objections. Within how much time?
Within 1 week.
Within 2 weeks, re-notify all.
2910,
Grateful.
Next,
serial number 10.
what are the reports to be filed by?
Tahsildar has to file report.
Tahsildar has to file a
Whether this
report.
land belongs to government or not, this court sought information from the Tahsildar, my lords.
No, there is an
supposed
order
to-
passed on 19/6/2024, my lord.
Then government has. to file.
There's a land grabbing, under the Land Grabbing Act, the proceedings were initiated.
You said 19/6, no?
Please, my lord.
What happened? Where is your report?
Not there. Next week, Lord, I'll file that.
We'll call otherwise the Tahsildar.
No, today morning I discussed the matter with the Tahsildar, Lord.
Yeah, otherwise we'll call him.
We handed out that entire.
My lord, on that
Monday,
way,
Lord.
on that submission that they will file a report, the stay was not granted, my lord. It's been almost,
We'll ask him,
3 months.
otherwise, if it is not filed, he will be present in the court.
Today morning, Lord, I discussed this matter with the Tahsildar. By Monday, Lord, I'll file.
Despite order dated 19/6/2024. The report as directed in the said order has not been filed. The learned counsel appearing for respondent, the learned AGA appearing for respondent number 1 and 2. Seeks how much time?
1 week, Lord.
Seeks and is allowed a week's time to file the report. Where is that report? To secure the report from the competent authority. It's made clear that if no action is taken, the concerned Tahsildar must be present in the court on the next date of hearing. Just give it after vacation.
my lord, till then, if I may request some order of protection where no precipitative action is initiated, my lord, there were about 30 to 40 years old mango trees in the property. They are now initiating some action to remove and cut those trees. The entire purpose of filing this petition would be frustrated, my lord, if some protection.
What was the petition filed for?
My lord, we are challenging the order passed by the land grabbing court where we have said that it is not maintainable. And the objections raised by us regarding the maintainability has been rejected.
Just give it within 1 week, just after 1 week.
Please, my lord, since there is some initiation of action, my lord.
We'll see that, we'll see.
Please,
26/9, sir.
Next.
grateful.
Serial number 11.
Please, Lord, on the last date, your lordship had asked us to file submissions. My submissions are ready. If your lordship permits, we go on for the reason that between the last date and now they have entered into a joint development agreement. The building is demolished. Matters are being precipitated. They have also filed their submissions.
We heard you now on that.
Please, my lords, and your lordship directed me to file submissions. I have the submissions ready.
Regarding pilot, what about you?
I filed, my lord. It's, all submissions filed and along with the judgments of courts. Yesterday I filed in office.
But I have also filed an application to implement those.
Hardcore.
Yes. What was the issue here?
My lord, the principal issue, my lords, was whether the Debts Recovery Tribunal has power to condone the delay in filing an original application under the provisions of the Surface Act. In my case, my lords, the Debts Recovery Tribunal dismissed my application.
No, under the original application, that would be under the recovery of the debt recovery.
Lords,
CDB
this is application that a borrower or a guarantor files under the Surface Act.
You filed under 17 against that.
Of the Surface Act.
That's right.
Please, my lords.
But against those orders which were passed under section 13.
Please, my lords. Against the sale under section 30.
Okay.
The Debts Recovery Tribunal came to a conclusion that there is no power to condone the delay.
You have challenged the sale.
I have challenged the sale. I filed an appeal. Before filing an appeal, I came to this honorable court. Therefore, even my appeal was delayed. My appeal is also rejected on the premise that my appeal itself is delayed. This, my lords, broadly is the. If
You
I
give
may
a copy of it, we'll just see. Today may not be possible.
Please, my lords.
We'll have it. Just say that, learner counsel for the.
My lord, I have also filed an application to implement the subsequent purchasers.
Who is he? Is he here?
No, my lords, I filed, I got to know that on
Copy not received.
2nd September, they have created further third.
Tell us one thing. DRT rejected your petition.
Please, my lords.
You went in appeal also against that.
Please, my
DRT
lords. That also rejected,
rejected.
both on limitation, not on merit.
Was the auction purchaser not a party before the DRT?
Auction purchaser was a party before the DRT. He is also a party here. Therefore, my lords, so
What is the application for now?
my lords, I have filed the application because the auction purchaser has gifted the property to his daughter. His daughter has
So you
entered.
want to implement the daughter?
My respectful submission is, my lords, that if it is heard at an early date, they have done it subject to the risk. Therefore, the petition itself could be disposed of. Otherwise, the only difficulty, my lords, is if your lordship will give me a short date, this application can be kept pending. They have demolished the property.
Just give a copy to him, re-notify the petition on, just give it after vacation immediately.
Lord, then until then, let them be directed to maintain status quo.
Who is appearing for the auction purchaser?
I am appealing for that.
You have gifted the property to the, to your daughter,
I gifted. There was no interim order, nothing in the.
but does she intends to
No, she
alienate
sold
the
it.
property?
Lords,
She has sold.
she has sold it.
She has also sold it.
She has sold it.
Fourth.
And
19 it was purchased,
between the last,
So when did you gifted it to your daughter?
23, after 5 years,
And when did she sell it?
in
Lords,
24.
she sold it after filing of this writ
Now
petition.
tell us one thing, who
Please.
was party before DRT and who was not party before DRT? Was this now the new purchaser was a party before DRT?
Lords,
No,
the
man.
present,
So I think then we will have it. We will not say anything. Let's have it after vacation.
Lord, my only request is they have demolished the property. They have demolished the property during the pendency of the writ
We
petition.
have to decide the list.
Please, my lords.
Today, we have to rather look at on the sale aspect. That
Please,
need to
Lords.
be seen.
Still, to more than 12 crores is due, my lord.
Okay,
That's also-
next.
Lord, my only,
10, sir.
my only request is until then, let them maintain
Say
status quo.
nothing. Today, even the gentleman is also not party. Is he here before us?
No, my lords, he is not.
Not, you have to cross that hurdle of the getting.
Lords,
his
therefore, I filed 2 applications. They are on record. Lords, one application is to
We will
implement
hear
them.
that application for implement also. Okay, next.
I have also filed not seeking prayer against those persons who are yet to be impleted.
That's right, you are right. See, they have to come first.
Please, my lords.
Next.
Serial number 12.
You have
Right.
given the date, ma'am?
2210.
Next.
On any shorter date, my lords.
Just give it immediately thereafter, 14-15.
1410, sir. Sir, 1410.
Grateful.
12.
May it please your lordships, my lords, this is the matter, my lords, on the interpretation of section 8(1)(b) of the Lokayukta Act. Well,
We'll hear, you'll pass over.
Thirteen.
Respondents 1 and 2.
I'm for the appellant in this case, my lord.
Yes.
My lord, some
My lord,
papers,
in
my
this
lord,
matter,
for the,
the respondent sought for the quashing of the notification issued by the Bangalore Development Authority, my lord. 7/11/2002 preliminary notification and 9/9/2003
What are
final
you saying?
notification.
my lord, some papers that was filed before the learned single judge are not part of the writ appeal, my lords. That's those
They are relevant.
My lords?
They are relevant.
Yes, my lords, they're relevant, my lords, because those were placed before the learned single judge. And the learned single judge has taken note of that. But my lords, probably by mistake, they have not annexed that.
You will file it or they will
My
file
lords,
it?
I've kept it ready, my lords, I'll file
You
it.
file it. The counsel for the respondents, you appear for all the respondents.
Respondents 1 and 2, my lords.
And who appears for 3 states that certain documents which form part of the writ record have not been filed. He states that the same shall be filed within 2 weeks. At his request, re-notify.
2910.
Obliged.
Next.
14.
Right. If the appellant in this matter. This is a case of being vexed repeatedly on the same issue. On, my lord, what has in our submission already been decided over and over again. And the 33C proceeding is still pending. And all these questions, my lord, which have now been raised, have to be answered in the 33C proceeding. And that's the finding, my lord, of the division bench of this honorable.
You're ready to argue? We'll just pass it over. Okay, pass over.
15.
Appearing for the appellant, sir. It's a minor
Appear for the-
inconvenience today. Date will be.
counsel for the
Respondent number 5.
aviator. Respondent 5. Lord, I have
Yes,
respondent 5 succeeded in the petition, quashing the order of appointment of director.
you want ready?
Date may be fixed, your lordship. Short date may be granted.
An entry mode running against Lord, this respondent, lordship.
What is the interim?
Status quo.
To maintain status.
But now what is the effect, Mr. Bhagwat, of that status quo? You are working
Lord, he is not working because he is unwell.
because of?
He is unwell, Lord. The appellant was unwell.
Huh?
Lord, the respondent 5 is placed in charge of the director.
Regular post to only 4 years. 2 years. 4 years, 10 years.
Short question is, Lord, lien under rule 20 of the KTSR. But 10/10/23, this court passed an order of status quo.
Tribal process, so where different EBI. Income.
No, but we just want to know, but are you not working anywhere?
Fifth respondent is in charge of the.
Yes, fifth respondent now placed in charge, my lord, because the appellant was unwell, he was not able to stand.
But you are working.
Yes, sir.
Adjournment is sought by the counsel for the appellant. We notify, it's made clear, no further adjournment shall be granted on the next date of hearing. Interim order, if any, to continue. Next.
Short date.
Very short date, my lord.
Yeah, we'll give you just immediately after that.
2310.
Next.
2310.
Seal number 16.
I appear for the appellant.
16.
There's some inconvenience will be taken
What
up on Monday.
inconvenience, ma'am?
Senior has some personal inconvenience, that's all, taken up on Monday. Either this Saturday or Monday,
Pardon?
either this Saturday or Monday minutes, subject to convenience.
No, Saturday is difficult.
Monday minutes, maybe.
Adjournment is sought by the counsel for the appellant. Re-notify on. Just give whatever suits.
16:10.
Shorter date, that's. before
16:10?
Before vacation.
No, not possible, ma'am.
17. serial number
Next.
17.
Yes.
My lord, the case pertains to PTCL Act, my lord. The land was granted to the fathers of the appellant in the year 1961, my lord. My lord, it is said that, my lord, in the year 1981, my lord, the father of the appellants had executed GPA in favor of fifth respondent, my lord. And who, by virtue of this GPA, my lord, has obtained a loan from the Picard Bank in 1984, my lord. My lord, day afterwards, my lord, in the year 1997, they have conducted the auction sale without intimating us. There is no notice issued us, and even the recovery proceedings were not initiated against us, my lord. No notice were issued to me. And moreover, as it is observed by the assistant commissioner while passing the order, restoring order, my lord, they have not obtained permission from the deputy commissioner, which is a mandatory under section 7 of the act, my lord. Before making this auction sale, my lord, they had to have obtained permission from the deputy commissioner. My lord, in the year 1997, the sale has been confirmed. And in 2001, my lord, we approached the assistant commissioner for restoration of the land, PTCL land, my lord. And in the year 2009, my lord, the matter was
GPA, sale deed, everything executed. And when was that?
in the year 1881, my lord, 1981.
Then, and on the basis of that GPA, a loan was taken.
By the GPA holder.
Bank initiated and through auction purchase, he is the auction purchaser.
Yes, my lord.
Then.
True, my lord.
How can you
And the
know?
mortgage, my lord, GPA created a charge, and initially the GPA, my lord, the GPA holder has obtained a loan. It is not the grantee, my lord. And moreover.
Right.
True, my lord.
You have given a GPA to him, he got it, bank invoked the loan and they sold the property.
Which is against section 5 of this act.
We don't know. Today, what is the end challenge is the auction purchaser has come.
My lord, even in the honorable single judge has observed that since the initial transfer of property, my lord, transfer of the title by virtue of GPA itself is wrong, my lord. Since the all subsequent transactions by virtue of this GPA will go, my lord.
Not.
And the single judge has considered only on the limitation grounds.
But in any case, loan given, loan defaulted, what will the bank do?
My lord.
They will invoke the security.
True, my lord, but because, my lord, there is no this thing to proof before this.
When did you approach the assistant commissioner?
In 2001, my lord.
When was the land sold or GPA granted?
1997. 1997, the auction sale was conducted, my lord.
When was the GPA given?
In 1981.
1981. Clear case of adverse possession in his favor. In favor of the GPA. You did not contest, you
my lord,
did not challenge.
My contention before this honorable court is that, my lord, even the execution of GPA itself is against to the purpose and object of
Well,
this
what
law,
did
my
you
lord.
do between 81 and 97? Did you make your claim? Qua the attorney?
We were in the possession, my lord. We were in the possession. We had a possession.
You had the possession?
Yes, my lord. And it was only My lord, it was the practice, my lord. My lord, it was practice, my lord, here in Karnataka, my lord, wherever
You
the,
were in possession
yes, my lord.
throughout,
Yes, my lord.
till the sale.
Yes, my lord. And my lord, here it is a practice that, my lord, whenever we,
You challenge the sale.
yes, my lord.
Did you challenge the sale?
It was not intimated to me, my lord.
How can that be?
So I was not I was not made, I had a party by the Picard Bank. It's only a
But-
GPA holder who was made a
The-
party.
When the property was put to auction,
Yes, my lord.
surely you will have the knowledge.
I did not have knowledge. That was my contention
The
before the
auction
assistant.
purchaser must have come to take possession.
No, he did not come, my lord. Immediately after that, my lord, we approached Assistant Commissioner for restoration of this order, my lord. The action said.
Who had approached? You had approached?
Yes, my lord.
When was that?
2001, my lord.
And see, 97, it's very highly unlikely. We
My
can't.
lord,
believe it.
I'll get some documents before to
We
produce
can't
before this
accept that.
honorable
How
court.
can that be a
My
your
lord, here, my lord, the practice is that, my lord, whenever we borrow some money from the person, my lord, they make a notional
Okay,
sale
when-
deed
when
or
were-
amount.
When were you dispossessed from the property? Tell us.
I have been in the possession, my parents, my lord.
When were you dispossessed? Now you are saying your parents. When
That's
were
what,
you
my lord.
dispossessed?
I will get the instruction, my lord. I'll get the instruction and I'll give along with the documents. I
We will not. We want very clear facts. Let's be very clear. You say we, then you say your parents were in there. Who was in possession of the
We
property?
were small kids, my lord. My Rudraya and Kenchaya were the original grantees, my lord. They had,
They may be, but were they in possession?
my lord, yeah, my lord, we were tilling the land, my lord. It was agricultural land. We were tilling the land.
We or they?
Our parents, the original grantees.
When were they, who was dispossessed? The grantee, when was he dispossessed?
Grantee was not dispossessed, my lord. We were tilling, we were in the cultivation of this property.
So grantee was not in possession? We take it that way?
No, grantee is my submission is that we were cultivating, only GP was met because we borrowed some money.
When
from
were
the
you
first-
dispossessed? We are asking you.
We were
When-
not,
when
only by document wise, my lord, we were, this thing, we were decided until by virtue of the sale deed, my lord.
When was the physical possession taken?
Physical possession was, they tried to attempted to strike a physical possession in the year 1997 after the sale deed was, action sale was conducted, my lord. Thereafterwards only, then only we came to know about passing of all this.
Are you still in possession?
Yes, my lord. Since 13 years, we have been in possession, my lord. We are in cultivation.
We are surprised that the auction purchase, you were not having any idea. The people will come, inspect the property. He will satisfy
My lord,
himself.
after
The
sale,
bank officers will come.
my lord, my respectful submission is, my lord, after the sale auction was done, my lord, then the revenue authorities came to dispose. Then only I came to know about passing of all these orders, my lord.
They have come to dispossess you, so you are dispossessed today?
No, my lord, I am in possession, my lord.
You are in possession. Now, how
Even-
did they conduct the auction sale? Under the SURFACE?
No, not my lord. Cooperative Act.
Oh, yeah, this is cooperative.
Cooperative.
Whatever document, what documents you want to file?
So I looked at the GP and other documents, my
File it
lord.
on record. File it on record.
Yes, my lord,
Then a counsel for the appellant seeks time to file on record certain documents which were part of the single judge record.
no, not my lord. From the recovery proceedings.
You will file it by way of an application.
Obliged, my lord.
The same shall be filed by way of an application. That is request denotified.
511.
Next,
Interim order kindly.
what is the interim order?
Interim order not to, the operation execution of
Has
single.
have they been served, man? Let's see who are,
Because we are in a possession, my
just
lord.
1 minute.
We have grown,
1 minute, please. Let's take out that matter. Item 16,
delay,
17. Not granted, huh? Okay. Okay, you file it. No interim order. Next. Next.
18. Chandrasekhar.
For respondent number one, my lords, I undertake to file wakalat today, my lords. Rajeshwara PM. Served with this copy, my lords, I appeared before the learned single judge for the petitioner respondent.
Eighteen. So and so appears for which respondent, ma'am?
Respondent number one, my lords.
States that she shall file wakalat within 1 week. Re-notify on interim order is to continue. We said that. Next, ma'am.
611. Serial number 19.
My lord, I appear for the respondents
Ah,
2
then-
to 4, my lord.
Appellant, my lord.
19.
Ma'am,
19.
just show item 18, ma'am. Item 18. On the sheet. Where is the counsel, ma'am, who appeared in your case? The other side. Is he there? Just ask him to come. Next, 18.
19.
I'm for the appellant in this case.
Appear for the respondents 2 to 5.
Yes, ma'am.
Lordship, I'm for the appellant. The property bearing survey, property number 10 was purchased by the appellant by the original owner G. Papaya Reddy, son of Gurumurthy Reddy. And by the original GPA and the agreement of sale executed.
You are ready? You appear for.
Ready, my lord. I appear for the allotee to respondents 2 to 4.
Agreement dated 18 May 1982.
Pass over, we'll pass over.
Please. Submission of the dates of.
Let's see.
Allah, pass over.
Pass over.
Please.
Serial number 20. Serial number 20. Parmeshwarappa.
But they dismissed, no? Dismissed. Okay, then we'll adjourn it. None for the petitioner, re-notify all.
Five 11. 21. Shri Prabhakar Rao.
I appear for petitioner in this matter. 21.
There are three matters, no?
No,
21.
21 CT Parameshwarappa.
21.
21.
Prabhakar Rao. Sir, list number 1.
Serial number, court list is serial number 1, pronouncement of judgment is there. Thereafter continuation numbers are there. But here the serial number 1 is deleted. It was, in our case list, serial numbers will continue, my lord. 21 is the serial number is calling out. 21 is the serial number is calling out, but in our list, it will be shown as 22, my lord. It's happening like that.
Just check up, ma'am.
Yeah,
We hope people have appeared in their matters. Or it is another matter they are appearing.
Yes, ma'am. That's what happened.
Yes, tell us what is there in this
Lord,
matter.
serial number 22,
Ah.
23 and 24.
Yes, tell us.
My lord, what has happened? Kindly see the page number 126, my lord, annexure C. Order passed by the tribunal.
What does the tribunal say?
Sir, which
Which matter lead, which matter?
17273, my lord, first matter, 22.
That's 21.
My lord, now that is mistaken and in my list it is in 22.
Okay,
Doesn't matter, my lord, I'm sorry.
now you must tell the officer.
What has happened?
ಅದು pronouncement ಅವ್ರ ತರ ಬಂದಿದೆ ನಮ್ಮ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
My lord, 129, my lord, page, annexure 6, my lord, the order passed by the CA. My lord, in this matter, what has happened? The issue involved herein is squarely covered by the decision taken by the tribunal in BOA number 446, my lord, because there are connected matters. Now, your lordship may kindly go to the 446, is in WP number 29043, that is in serial number 32, my lord, which is posted for final hearing. My lord, in that writ petition, I request your lordships to take the order passed by the bench dated 12/7/2024, my lord. 12/7/2024. Sorry, my lord, that is on 27/5, my lord. In WP. My lord, all the connected matters have been admitted and rule have been issued. Therefore, these three matters also have to be connected to the serial number 32, my lord. One and the same. No, because of the by virtue of the interim order, we have stopped the inquiry proceedings. Now, my lord, these three matters have to be connected to 32, my lord, after passing the similar orders. But because it was listed for hearing, that's all.
You can hear together.
We can.
Please.
Pardon? Charge, the facts are similar, the matters are similar. My lord, I have one more submission. There is another matter. There are totally 5 matters, my lord. Now, before your lordships, serial number 22, 23, and 24, and 32 are there, my lord. Another matter has to be connected, my lord. The same, between the same parties. Date is not given, my lord. 17506/2024, WP. My friend also knows that, and I have served the copy also on it.
The lordships decide the final hearing, serial number 32. That would follow. Yes.
Where in first matter, my lord, 32, my lord.
Page 151, my lord, is the order. The findings, my lord, would start at page number 159, para 6.
May I request one submission, my lord?
It
No,
was
but not-
articles of charge. that was-
Articles of charge, at the stage of articles of the charge, the tribunal interfered and quashed the charge sheet. It is against the judgment of the Supreme Court, my lord. I have already produced the compilation of the judgments.
Please. All.
Then why a demonstration? Demonstration, anything.
Please.
See, your status is of more of a government body,
Absolutely.
like.
Yes.
Yes.
It's the only issue, my lord, that I raised.
Just to proceed with the inquiry.
My lord, what has happened, my lord? This, the entire genesis of this demonstration, my lord, within the premises of the director. And that too, mine is a hospital. My lord. in the hospital, they have gone to the extent of making demonstrations with respect of charge sheet issued to XY judgment. The fact-finding committee comprising of Justice N. Kumar of this honorable court, that also I have produced it, my lord, gave a clear sheet that there is no interconnection between the charges and as well as the complaint which led to the demonstration. What we will request your lordship is, let these matters be connected and I will address arguments on the final matter. All the five WPs can be disposed of. Let the date be fixed. I have also filed the compilation of several judgments and I am hardly relying on Railway Board's case. In the Railway Board's case in 1969 Supreme Court, what it said was that no demonstration can take place in the public premises within the premises. It does not affect Article 19C. Therefore, my lord, their entire demonstration itself is illegal. I will demonstrate that, my lord. Let us go into that aspect of the matter. Let the law be laid down by this honorable court. That is my submission. A date may be fixed after connecting all these matters.
Towards this matter. Whether, my lord, of course, at the stage of articles of charge, my lord, the scope of interference is absolutely narrow. May I make this request? The tribunal would come to the conclusion, my lord, that the incident that is being complained of and the incident in respect of inquiry is sought to be held does not amount to a misconduct at all.
That can be decided in the inquiry, not at the stage of writ proceeding. That's what the Supreme Court said.
Misconduct is defined under the conduct rules. What is complained of is misconduct of violation of Rule 7 and Rule 9. The tribunal, my lord, would examine both these rules and say that it does not fall within the definition of either Rule 7 or Rule 9. And therefore, my lord, would set aside the articles of charge. That would be, my lord, basing on the observations made by your lordships, which was confirmed, my lord, by the Supreme Court. This court would come to the conclusion after looking into the articles of charge that the charge of, my lord, speaking to the public against the demands, against the institution is in fact not by the employees, but by the person who has issued the articles of charge. And, my lord, this tribunal, this court, my lord, did not look into any other material other than the articles of charge. My submission to your lordships is at the stage of articles of charge, your lordships can only look into the articles of charge and interfere only on 3 grounds. One is jurisdiction, if it does not amount to misconduct, or malafide. It is on all 3 counts, my lords, that the tribunal as well as this court.
That being a government servant, my lord.
Absolutely. Yes.
And also, my lord, one aspect. Sorry for him.
You can put fighters in, so possibly we can put in.
Very well. I have, yes. The employee and employer, absolutely. Absolutely.
Elsewhere.
Yes. This was the only incident, even though notices were issued for other dharnas, I have advised them and that has not taken place. Therefore, yes, we can put a quietus, my lord. I am completely agreeable to your lord.
My lord, it is like this, my lord. I have already initiated departmental inquiries. Inquiries are going on.
Great.
611.
You want to have a time left?
Great.
24, Shri Nagarajappa. Shri Nagarajappa.
Preparing for the petition, sir.
Yes.
And the petitioner was working as a lecturer in the, my lord, the private aided institutions. My lord, the issue regarding issue related to 2005, my lord, are the articles of charges issued in the year 2017 under Section 8 of the Local Act, its boards from both the angle. But I have stated, my lord, in the reply, second reply, I have stated. And obtained, and I have also, apart from, my lord, with
You are ready to argue?
yes, my lord,
Counsel.
please.
Twenty-five, Srihari NS.
Notice the short point of this petition is, my lords,
Yes.
whether proof without pleadings can be permitted, my lords. Whether proof, evidence without pleadings can be permitted. That is the short point involved with this.
Response you have come.
My lords,
Come on and respond, liberty granted to file response.
please, my lords, not liberty granted to file response, liberty granted to lead evidence and documents if any, while the version was never taken on record. Version was never taken on record. Beyond 45 days, my lords. Let the interim order be, let there be an interim order staying the operation of the order. Because the next date of hearing is on 4/10 and it is reserved for leading evidence of the OPs.
The challenge in this petition is the past.
Karnataka State Consumer Disputes Redressal Commission. Commission, please.
RP number 201. That the petition, that the has omitted the respondent hearing. You had not filed a response to the complaint.
Yes, filed, but it was after 45 days.
Filed but not taken on record, having been filed after 45 days.
From the date of service of notice.
45 days is the date of service, the commission has permitted the respondent to file an affidavit.
My lords, liberty to submit affidavit evidence along with documents if found.
According to the learner counsel, the response reply to the complaint having not been taken on record, such a order could not have been passed by the commission. The sufficient command there is a prayer for intervention.
My lords will find that at page number 11, my lords, of the writ petition.
Number 201.
Grateful, my lords. I may also be permitted to serve the counsel appearing in the before the.
Serve the counsel hearing for the respondent before the.
Seven eleven.
Two respondents, my lords, out of which technically only OP2. For both the response, they're one in the same entity, my lords. One is the branch office, the other one is the registered office.
Twenty-five, 160.
25,163, my lords. Lords, the revision petition was filed at the behest of OP2. In any event, lords, that is fine. Respond to both. Lords, may I kindly request 8th of November, my lords, instead of 7th of November.
8th of numbers.
Deeply obliged.
Serial number 26, Shri Prakash Shetty.
My lords, I appear for the petitioners, my lord. This is an identical matter, your lordship says, the my lord, this is a transfer of the ESI hospital, my lord. The West Side identical issues, my lord.
I appear for the
respondent in this matter. What is the date, Mr. Shetty, there?
14th, my lord.
14/10, my lord.
You notify 14/10.
14/10, sir.
Next.
57, Shri George Anthony.
Petitioner, my lords, the arguing counsel is not well, my lords. Kindly have it on Monday or Tuesday, my lords.
And this petition per se, it appears not maintainable.
My lords, kindly have it on Monday, my lords.
Very well, we'll have it on Monday.
Yes, please, my lords.
The request of counsel for the petitioners for an adjournment on the ground that the counsel, arguing counsel is unwell.
Yes.
Re-notify Monday.
23/9.
That's okay.
Next.
28, Shri Pramod.
Happy for the petitioners. Lords, this matter was heard on 12th of September and posted today, my lords. In this matter, my lords, the respondent applicant, my lords, belongs to a SC category, and he sought for a promotion or appointment to the MTS, my lords. At that time, in the year 2015, my lords, there were no vacancy for SC category, my lords, which I pointed out last time.
Is anyone appearing?
One counsel has been
There is
appearing,
no representative.
but
We'll
he was,
hear you.
please, my lords.
Pass over. You can dispose it off. Hear it. Yes, see, what is the issue? Show us.
My lords, if my lords is page 28 for a moment, my lords. This is the order, page 28, my lords. My lords, tribunal refers to vacancy in the year 2015, refers to a tabular column. Then it says there are 8 vacancies. Then there is no need for the respondent to say that 2 vacancy apportionate for seniority cum fitness where earmarked.
So you say this was not meant for
SC, my lords.
no, SC against that, which is the category. What is the nature of recruitment? Under which provision? 25%?
25%, my lords.
GDS?
GDS, my lords, from GDS to MTS. If my lord sees page 120 for a moment.
And where is your, where did you say that there is no vacancy?
My lords, page 120. Along with the reply, it was filed. Annexure R13, 120, my lords. There, my lords, MTS vacancy in respect of subordinate office for the year 2015. First one is 25%, 2015.
We are for the first one, huh?
First one, only first one. And later on, my lords, in the year 2018, after filing the writ petition, my lords, subsequently he was considered.
And he
was appointed, which
year he was appointed?
My lords, against SC vacancy, my lords, same category.
Year?
2018, my lords. For the vacancy year 2018, he has taken charge and he has retired also in the year 2022, my lords.
He retired also. The challenge in this petition is to an order passed by the Central Administrative Tribunal in OA number 170/000744 of 2017. Whereby the tribunal, 1st March 2019, tribunal has allowed the OA by stating as under Mr. B. Pramod and a counsel appearing for the petitioner would submit that the subject matter of challenge by the respondent was to a recruitment undertaken by the petitioner in respect of in the year 2015. According to him, by drawing our attention to page 120 of the paper book, the recruitment being under the 25% quota meant for direct recruitment from amongst the GDS on the basis of selection cum seniority, there was no post which was reserved for SC category, and hence the respondent who belonged to SC category could not have been considered. Despite such a stand taken by the petitioner, the tribunal has allowed the OA in the manner it has done in the impugned order. He also states that in the subsequent recruitment year,
the petitioner has been promoted or appointed?
It's an appointment.
Appointed as MTS.
Please.
And also the fact that he has since retired in the year 2022. We find there was no appearance in the last, just say that on the last date of hearing, we noted that as there was no appearance, the matter be adjourned. Today also, there is no representation on behalf of the respondent. In view of the submission made by Mr. Pramod and also noting the fact at page 120, from page 120, it is clear that there was no vacancy for SC, the petitioner who belonged, the respondent who belonged to SC category could not have been considered for appointment to the post of MTS under 25% DR quota from amongst the GDS. The order of the tribunal is clearly unsustainable. And as such, the same is set aside. Petition disposed of. Next.
29, Shri Surana. PD Surana.
A RERA appeal was filed. On a complaint filed by the respondent, the proceedings of in the RERA court were dropped on the ground that it was not an ongoing project. 95% of the project, the sales were executed before the RERA came into force. So the proceedings were dropped. Against that, appeal was filed. Unfortunately, in the appeal, no notice was issued, no notice was set upon me. Only on the postal track record, the appeal has been disposed of, saying that notice is served. May I pass on the postal track record? I have taken the obtained certificate.
What does the postal track report say?
This is the, I have obtained certificate copy of the same.
Was it not served on you?
It's not served on me.
I'm the father of the respondent.
You are the father of the?
Respondent Karishma.
I only pray for an opportunity to be given before the RERA authority.
Karishma Shah. So who is your counsel?
So Nagaraj, he's held up somewhere.
Just to call him. You say you were not heard, that's all. Just see. Just call your counsel. Let him come. Pass over. Next.
30, serial number 30, Shri Janardana.
Yes.
Not the petitioners are all, appellants are all lecturers working in respond number 7 to 10 colleges. And it's a aided institution.
Who is appearing for the other side?
Government and.
Huh? See, you have to remove certain objections
Not that
about the
is,
court fee.
the
everything.
second matter, first matter I have submitted, second matter kindly, second matter, what they say is all the petitioners were not made parties in the writ. But the first matter, they are all parties. They could not file it together. They have filed it on two petitions. So they have paid the court fee accordingly and necessary court fee has been paid. So office, you know, we explained, they raised that it is not.
No, but are they appellant before the second matter?
Yes, only the first matter.
But what about the second matter?
Second matter, two of them were not joined at the time of all the petitioners among them, but two petitioners were not joined at the time of first appeal was filed.
So you have to file the court fee, na?
But I have paid the court fee.
In the second matter?
Second matter also for two persons have filed, I have paid the court fee. They want all the 16% to be paid court fee in the second matter. But in the first appeal, they were already paid.
1 minute. Let's see who are the what is the memo in the second appeal?
Yes. The that in the second appeal.
There are two appellants.
Yes, ma'am.
You have filed court fee for these two appellants?
Yes, I have paid. 200, I have paid the pay.
And the court fee is on the basis of the number of single petitioner or single appellant?
Single, yes.
The number of petitioners or the appellants, as the case may be?
Yes.
How much is the court fee?
100 rupees per.
Per appellant per piece?
But I have paid that.
Okay. Then what? Okay.
But then, but the parties are concerned. But parties, they say petitioner's number, writ petition number, but what 10 to 1 to 7 and 10 to 12 were not made parties in the appeal. But they are the parties in the writ appeal, first appeal.
But how are they concerned? Maybe two appellants wants to come.
This is the objection.
Okay. Where is that non-compliant office extent? PN, Peter, and reputation are not made party in the writ appeal, and to be clear. What is this? The office objections in respect of WA 1164/2023 as highlighted by the learned counsel for the appellant is that insofar as non-payment of deficit court fee is concerned, comma, since there are two appellants, the court fee as appropriate has been deposited. Full stop. He states that since an objection has been raised that petitioner 1 to petitioner 7 and petitioner 10 to 12 who were in the writ petition have not been made parties. Did you not make parties them? See,
No.
that's the point.
Yes, they are here in the first pattern. Lord. They are already here. Lord.
If let's look, see what what's the registry saying is this. There were 10 petitioners and 5 respondents.
Yes.
So how many are there cumulatively?
Lord,
10 and 5, 15.
yes.
So all 15's position need to be reflected in the
Cost
memo of parties in the cost title in appeal.
Yes.
What did you do? You made 2 appellants.
Yes.
And
Yes.
Only 5, no, 7.
Yes. Yes.
But you have deleted rest 8.
Lord, what
Their
happened?
status has not been reflected.
But I have not reflected. Reason is, but I stated since the connected appeal, they were already made before the court. That's why I explained that if technically if necessary, that it is only a technical issue that I can cure it, no problem. Now, anyhow, not all of them are before the court. No, I accept the technicality. But anyhow, all of them are before the court. If your lords ask me, I am ready. It is a curable one. I
Can
will.
include them.
Yes.
And possibly say performer respondent already filed an appeal being
Yes.
so and so.
Right.
Let that formality be.
All right, I'll do it. No issue.
Just say this, just cut it off. And this objection, second objection is relatable to the first one.
Yes. That is one, but if they are responded, they need not pay the court fee.
They need not pay. Okay. Insofar as the second objection is concerned, the learned counsel states that the objection shall be removed within 2 weeks from today.
But may make one second. But lords may, because all of them are almost retiring, not benefit from 2012 has been denied, even though they're granted with EGC pay scale, grade pay has been sought for to increase it from 6,000 to 8,000.
What do you want?
But I want 2 days, but I'll do it by Monday next lordship.
We'll have it after vacation. Next.
But,
Who is otherwise appearing? You are
a
appearing?
date may be given. Lordship may give the date.
Yeah, re-notify on.
2410,
Next. 31,
31 adjournments.
33, 230. All the parcels.
Passed over matters.
Serial number 33, may I make a mention, my lords? Though it is at 2:30, I appear for the
Yes.
respondents in serial number 33.1. I have also separately preferred an appeal. It may be tagged and date may be fixed, my lord. I have informed the other councils.
No, ma'am, let the matter be taken up at 2:30, ma'am. Let the councils be there. Next.
Very good.
32 is connected with 21 to 23 minutes. Serial number 32.
31, Prabhakar.
Yes.
32.
32.
Okay.
21 to 23 are already adjourned. Date may be fixed.
611, same dates.
Grateful.
Passed over matters, serial number 12. Serial number 12, Shri Prashant Gowda.
Yes, come.
May it please your lordships. My lords, this matter, my lords, is in. My lords, this matter is on the interpretation of section 8(1)(b) of the Lokayukta Act. And also, my lords, whether the principles of natural justice as contemplated under section 9 have been complied or not. My lords, since on the last occasion, my lords,
Just
since,
come again, what did you say?
my lords, two primary contentions,
yes.
my lords. So one is the applicability of section 8(1)(b) of the Lokayukta Act. Under that, my lords, it is my primary contention that the complaint, my lords, is in the nature of a grievance and not in the nature of an allegation. My lords, the sequitur to the complaint being in the nature of a grievance would be that the bar under section 8(1)(b) would apply. My lords, 8(1)(b) says if there is any other remedy available in law, the aggrieved person should avail that remedy and not come before the Lokayukta or Upalokayukta. That would be the first limb of my argument, my lords. The second limb of my argument would be that the principles of natural justice as contemplated under section 9(3) has not been complied with. My lords, this goes whether it is a complaint in the nature of a grievance or the complaint in the nature of an allegation. Natural justice has to be complied with. In this case, what has happened, my lords? Investigation has been carried out by the Upalokayukta. A report has been filed under section 12(1). My lords, and a 12(1) report can only be filed in cases where there is a grievance. It cannot be filed in cases where there is an allegation because that is contemplated under section 12(3). So, my lords, having filed the report under section 12(1), my lords, without giving me a copy of the complaint, without hearing me, my lords, that action is bad in law. I'll also place those relevant judgments. My lords, very quickly, my lords, since on the last occasion I had gone through it, the scheme of the act in less than 5 minutes, I will just run through it only for my recapitulation, my lords. My lords, may have the Lokayukta Act of 84.
Yes.
My lords, I'll just flag the relevant provisions. My lords, action into 1.
So you are saying for applicability of 8 and 12(1), it is the grievance.
Yes.
That's all.
That's
Show the judgments.
My lords, that would also be on the first principle. I will come to the judgments. If my lords may kindly have section 2(1), which is the action. My lords, the action here is the auction of 27/1/2017. My lords, may only note one thing. The petitioners before my lords are two persons. One is the petitioner number 1 is the sales officer. Petitioner number 2 is the recovery officer. My lords, under the scheme of the Karnataka Cooperative Societies Act, the recovery officer authorizes the sales officer. The sales officer conducts the auction. Thereafter, my lords, in this case, I will show that relevant document. The sales officer says it is a consortium of 5 banks which lent certain monies. It says the decision is subject to the consortium. It is not the sales officer's decision which is final. The consortium of banks say we are okay with this auction price. 5 consortium banks say we are okay. And thereafter, my lords, till today, the auction is not confirmed. My lords may kindly note this, the sale is not confirmed. It is that action of 27/1/2017, which is at page 83.
Why is it not confirmed?
My lords, because of various proceedings, my lord. In fact, the successful bidder, he has now, my lords, moved this honorable court before the learned single judge, and he has said, I have paid the EMD amount of 8 crores. Now kindly deposit that in fixed deposit so that at least I get the interest. That is a parallel litigation, which the successful bidder. But my lord, this list, now the auction bid, the action of 27-1 is today pending before the revisional authority under section 108 of the Karnataka Cooperative Societies Act.
Is that 108?
My lord, I'll just place 108 of the Karnataka Cooperative Societies Act.
Although those issues are not related.
My lords, it would have a direct bearing, my lords, because this would be the only point. Because 8(1)(b) says, if there is any alternative remedy. Now, my lords, kindly see who is before the revisional authority. 2-3 people are before the revisional authority. One, the very factory whose properties were auctioned. That is one Bhadra Sugar Cooperative Factory. They have gone before the revisional authority. 2,
What ground they have gone?
my lord, the very same ground, saying
Challenging.
the auction, saying that the properties are valued much more and it was undervalued and sold at 54 crores. According to them, my lords, the value is much more, over 100 crores.
Who is the second one?
The second one, my lords, is one Gyan Bagh. He was the lessee of the sugar factory.
He is the
Lessee of the sugar factory.
lessee.
Lessee, my lords.
Huh.
He moved this honorable court, challenging the very same auction on 27-1-2017. This honorable court said, 108 is very wide. Please go before the revisional authority and agitate your grievance there, because it is the very same grievance which is pending before the revisional authority. Please go before the revisional authority and agitate your grievance.
What was the ground for challenge?
Again, same ground, my lord, saying that 54 crores is on the lower end. My lords, may
Challenging the sale.
challenging the same. My lords may also note one more interesting fact. There were two complainants before the Lokayukta. That is respondent number 6 and respondent number 7 herein. One of them, respondent 7, one of them, that is respondent number 7, directly came before my lords and challenged the same by way of a PIL. That PIL came to be dismissed as it was not pressed.
Not pressed or?
As not pressed, my lords. Now, my lords, I will also place a judgment of this honorable court which says when you have availed another alternative remedy, again 8(1)(b) hits. Following Kumaraswamy Minerals, my lords, I'll place that judgment also. Now, my lords, this is the brief of that, my lord. Now, if my lords my lords had asked me to place 108 of the Cooperative Societies Act. My lords has 108 minutes. Powers of the revision of the state government. Subject to the provisions of section 108A, the state government suo motu at any time and on an application, my lords may note these words, any person aggrieved, this would be crucial, my lords, any person aggrieved within a period of 6 months from the date of any order may call for and examine the record of any case or proceedings of any officer subordinate except those subject to appeal or revision by the tribunal or in those respects of which an appeal has been made and pending before the state government or other authorities under 106. And the state government, after in such inquiry as it deems fit, is satisfied that the order of that officer is contrary to law and has resulted in miscarriage of justice, pass such orders thereon as the state government deems just, provided that no order shall be made to the prejudice of any person under this section unless he has been given a reasonable opportunity of being heard. Now, my lords, coming back to the Lokayukta Act, my lords, I'll just flag the relevant provisions. I won't place it, my lords, because last 2(1). 2(1) is action. Just for convenience, my lords, I also have a change the date. No. Yeah. 27. My lords, I also have a note, my lords. I'll just so that. No copy. Give one more copy. My lords, the present list pertains to the auction proceedings dated 27/1, my lords. That there was a mistake. It's 27/1/2017, wherein the properties of one Bhadra Sahakari Sakre Karmanika came to be auctioned. In the auction proceedings, petitioner number 1 was the sales officer and petitioner number 2 was the recovery officer. On a complaint made by respondent number 6 and 7 before the Upalokayukta, after investigation, a report was filed under section 12(1) of the Karnataka Lokayukta Act on 1/3/2018. The section 12(1) report and proceedings emanating thereof are challenged in the present proceeding. Now, my lords, the relevant provisions, action, that is, my lords, the action is the 27/1/2017 proceedings, that is section 2(1). I will not trouble my lords with that. 2 pertains to allegation. My lords, as my learned senior friend said, my lords, allegation is, my lords, there I'm in agreement, is in larger, my lords. It may be in rem as such. Grievance may be to a particular individual, my lord. Here, the complainants are, my lords, employees, my lord. So it is in fact a society, it is their grievance, my lords. It would be my case that it would be a specific grievance. Well, my lords may kindly have page 122.
Complainants were the employees.
Yes, my lord. My lords may kindly have 122.
Page 1, section.
No, my lords, 122 of my paper book. The report. My lords has that. The subject itself, complaint filed by so and so, Bhadra Cooperative Sugar Factory Laborers and Employee Society. The top subject itself. Directly, my lords, they are employees. It's a society of employees. Now, my lords, section 7, grievance is defined in section 2(8). It would be my case that it is a case of grievance under 2(8). Maladministration is defined under 2(10). I won't trouble my lords reading those definitions. Now, my lords may kindly have section 7. Section 7 of the Act. My lord, section 7 begins like this. Matters which may be investigated by the loci.
Yes.
Matters which may be investigated by the Lokayukta and an Upalokayukta. Subject to the provisions of this Act, the Lokayukta, we are not really concerned with 7(1) because that is the powers of a Lokayukta. We are concerned with 7(2). Subject to the provisions of this Act, an Upalokayukta may investigate any action which is taken by or with the general or specific approval of any public servant, not being the chief minister, minister, member of legislature, secretary, or other public servant referred to in subsection. My lords, I'll read it like this, my lords. Subject to the provisions of this Act, an Upalokayukta may investigate any case. I will just skip those few lines. Any case where a complaint involving a grievance or an allegation is made. In respect of such action or such action can be or could have been, in the opinion of the Upalokayukta, recorded in writing, subject of a grievance or an allegation. So, my lords, 7(2) specifically says, be it a grievance, be it an allegation, the same may be investigated by the Upalokayukta. Now, my lords, it is very interesting here. The word is may, because why does the legislature use the word may here, my lords? Because 9(3)(9) contemplates a preliminary inquiry. So, if on a preliminary inquiry they find this is a fit case to close right here, they will close it right there, and then 9(5) and 9(6) would kick in, my lords. So it is not the Lokayukta or Upalokayukta shall investigate.
Yes.
Thereafter, my lords, 7(2)(a), we are really not concerned with 7(2)(a). 7(2)(a) is the suo motu power. Thereafter, my lords may kindly have section 8. except as hereinafter provided.
Yes.
The Lokayukta or Upalokayukta shall not, now here my lords, the word is shall not conduct any investigation under this act in the case of a complaint involving a grievance in respect of any action. A, I will skip my lords because we are really not concerned with A. 8.1a I will skip. 8.1b. If the complainant has or had any remedy by way of appeal, revision, review or other proceedings before any tribunal, court, officer or other authority and has not availed of the same. Now, my lords, here my submission would be twofold. One is the complainant here has availed of a remedy by way of a PIL, that is respondent number 7, respondent number 6.
Tell us one thing.
Yes.
At least under the scheme of act, subject to what you say, there is a provision to look into it, which may lead to a criminal prosecution.
My lords, the report would consequentially lead to it, my lords.
Very well.
But also, my lords, under the act, sorry, my
Will still
lord.
be, the query is this, will still be,
Yes.
even though it can lead to criminal prosecution, the provision need to be read in the manner what you are saying.
My lords, in fact, under section 14, direct initiation of prosecution can happen under section 14, my lords.
If that is so, let's test your argument. If that can happen, can still the remedy under 8.1b would still be an obligation?
Yes, my lords, because this is independent, my lords.
That's right, we want to know, that's the reason. So what you say is, where there is a remedy, you will avail remedy. But the Upalokayukta is not precluded from initiating also.
It is not, my lords, because if, let me put something against myself, my lords. Let me assume they comply with, let me assume it is an allegation. They complete the investigation as contemplated under section 9. After that, my lords, they directly, rather than resorting to 12.3, they directly initiate prosecution under section 14. I cannot have a grievance, my lords. That would have to be challenged in a 482 proceedings. The prosecution, if at all.
Now, what we want to know is, in that eventuality also, can an argument be taken? Look here, there is a, no, what you are saying, then the roles are different.
Yes, my lord.
One is a Lokayukta initiating the criminal prosecution.
Yes.
But based on a report?
Yes.
That's right?
Yes, my lord.
Now, if that be so, then, and how will he initiate criminal prosecution? It's only when a report has come under 12?
Yes.
Okay. Now let's assume hypothetically, in this 12 report, there is a recommendation for prosecution. Can you still argue, and based on those complaints only by the same complainant 6 and 7?
Yes.
Can you still argue that they have to go, they have to avail the remedy as available to them, and this report cannot be acted?
My lord, I will put it slightly. I follow. I will answer straight away.
Hope we have tried to convey ourselves.
I'll straight away answer my lord's question, my lord. If it is a report under 12.1, as in this case, my lord, one, this goes without saying, the principles of natural justice would have to be complied. My lord's question is not so far as that is concerned. So, my lords is putting this direct question to me, saying that if there is a report under 12.1 and also there is a recommendation for prosecution, then what would happen? My lord,
then you will still argue that
my lords, my answer would be this, my lords. If, my lords, it is only restricted to 12.1 and, my lords, it is a general recommendation, then, my lords, in any case, my lords, the subject matter being the very same, in this case, then, my lords, it would have the bar under 8.1b would come at the threshold bar. But if it is a report under section, if it is an initiation of prosecution under section 14, then the bar under 12.1 won't apply, my lords, because 12.1 and section 14 operate in different spheres. My lords, 12.1, a threshold bar would kick in of 8.1b. It is a threshold bar, my lords. What the legislature's intent is very clear. Then, if they wanted to straight away initiate prosecution, They may not even have given the 12-1 report. Let us say it is so
No,
heinous.
but that's permissible. A report under 12.1 is permissible where this recommendation is made.
My lords, respectfully, my lords, it would be bypassing the 12-1 stage. It would be straight after investigation, without going to 12-1, it would be a 14 action. My lords, I will just place 12-1 and 14.
No, but that's what we want to know.
Yes.
You must have looked into the provisions of the act. Now, a case of this nature, there is a report under 12.1, which says recommends prosecution.
Yes, my lords.
That is permissible?
My lords, but they cannot get over the bar of 8-1B would be my respectful submission.
What we are asking.
They cannot.
We are asking, you're
Yes.
right.
Yes.
That's the query we are
Yes,
putting in.
yes.
Can in that eventuality also, the bar under 8.1B will kick in?
Yes. Because my lords, strictly, if my lord sees page 128, they don't recommend prosecution.
You're not understanding.
But if they recommend prosecution, it would not be an action under 12-1. It would be 14.
That's what we want
Yes.
to understand. That's the reason, see, our query is, let's assume there is a report under 12.1 in this case, let's assume there is a
Yes.
report here. Instead of the recommendation as made here, there was a recommendation for prosecution.
Yes, my lord.
Is it permissible? We want to know.
My lords, my respectful submission is it would still be hit by 8-1B, my lord.
No, we will, that's a secondary question. So let's assume.
Under
it's-
14, it would be permissible, my lord. There will be a hyper-technical approach on my part.
No, we want to understand. See, we are construing the
Yes.
provisions of the act. We know,
Strictly, my lords, under 14, it would be permissible.
we are not going to 14. Our query is only under 12.1.
Yes, my lord.
12.1, there is a recommendation
Yes, my lord.
for prosecution.
Yes, my lord.
We will ask the other side also.
Yes.
If that is so, once there is a recommendation for prosecution, still this bar of 88.1B would still kick in.
My lord, respectfully, yes, my lords.
Oh,
The
very well. That's
8-1B
it.
would kick in, my lords.
That's your.
Because that
view,
would be a threshold bar, my lord. But
That's
I will
okay.
place 12-1 also in its
You
entirety.
can be right. You may be within your rights to argue
Yes,
that. That's a threshold bar.
Threshold bar, my lords.
But you will make your submission good.
Yes, I will make
How?
I will make my submission good. But my lords, just to put things in perspective, at 128, page 128 of my paper book.
See, it's like this.
Yes, ma'am.
We will put to you, Mr. Gautam, we will just tell you. In this facts, you were arguing in this.
No, my
fact.
lords, we have to assist my lords on law, my lords. It's not because it has ramifications.
Because it will. So, if under 12.1, so we say on an event, see, we have to, while construing it, we have to contemplate all eventualities.
The larger picture, my lords, it's not only restrict. I follow, my lords, and I'm only assisting my lords. I'm trying to be, I'll put what is against me also, my lords. I have judgments against me. I'll place that. My lords, we only have 128. Therefore, in exercising the powers, para 13 minutes. Therefore, in exercising the powers conferred under 12.1, the following recommendations are made to the competent authority to take action in the larger interest of society. 1. Recommendation is made out to conduct an inquiry and investigation into the formation of the Davangere Zilla so-and-so and also auction sale proceedings through COD. Recommendation is made to take disciplinary action against all erring officials who are responsible. Recommendation is made to take action to cancel the auction sale proceedings. Now, my lords, coming back to the act. My lords, I place section 8. Except as hereinafter provided, the Lokayukta or Upalokaykta shall not conduct an investigation under this act in the case of a complaint involving a grievance in respect of any action. B. 8B. If the complaint has or had any remedy by way of an appeal, revision, review, or other proceedings before any tribunal, court, officer, or other authority and has not availed of it. Now, my lords, may kindly skip to section 9. Subject to the provisions of this act, any person may make a complaint under this act to the Lokayukta or Upalokaykta. I will skip 2, my lords. Again, it is procedural in nature. 3, where the Lokayukta or Upalokaykta proposes after making such preliminary inquiry as he deems fit to conduct any investigation under this act, he shall A. forward a copy of the complaint, and in the case of an investigation initiated suo motu by him, the opinion recorded by him to to initiate the investigation under subsection 1 or 2, as the case may be, of section 7 to the public servant and the competent authority, shall afford to such public servant an opportunity to offer his comments on such complaint or opinion under subsection 1, as the case may be. Then, my lords, 3A and all came in. I'm really not stressing on that. 5 and 6, my lords, contemplates if, my lords, after the preliminary inquiry, at that stage itself, there is a closure. Then what happens is contemplated. We are really not concerned with that. Now, my lord, section 11 deals with in the manner of recording evidence, but this is again a stage prior to section 12. It is at the investigative stage. Now,
But your case is not investigative. It's
yes,
everyone.
no, my lords. It is after investigation, because, my lords, if a report under 12.1 or 12.3 has been filed, the investigation has to be carried out. And in this case, my lords, the investigation has been carried out.
Very well.
My lords may kindly see page 123 of the paper book, which would demonstrate this point. 120.
One thing.
Yes.
If that be so,
Yes.
investigation carried out,
Yes.
what 8 contemplates is that shall not conduct any investigation.
Yes.
Huh?
Threshold bar.
Threshold bar. But that would only be a plea which can be taken when investigation has not yet started. Look here, you can't now get into the investigation because you have a remedy under 8.1B.
Yes, my lord.
Now, in this case, we are putting it to you. That stage has crossed.
I bow down, my lords. But my answer is this, my lord.
Yes.
If I was put on notice, if the principles of natural justice were complied with, I wouldn't have permitted this stage to be crossed. Now, when do I come to know about this?
Let's see that process where you were to put to notice.
Yes, my lord. That comes under section 9.
9 and
Now, my lords, if I may just come back to 7, because 7, 8, 9 is a scheme, my lord. 7 begins with the heading matters which may be investigated by the Lokayukta or Upalokayukta. Undoubtedly, this comes under 7.2. 7 uses the words may. Now, my lord, section 8. Section 8 uses the words matters not subject to investigation. The heading is matters not subject to investigation. The Upalokayukta, except as hereinafter provided, the Lokayukta or Upalokayukta, my lords may emphasize on this word, shall not conduct an investigation under this act in the case of a complaint involving a grievance. In respect of, then I'm not going to again place 8.1b. Then my lords may come to 9. Provisions relating to complaints and investigations. Subject to the provisions of this act, any person may make a complaint under this act to the Lokayukta or Upalokayukta. Then, my lords, I'll for completion, I'll provide the place even the provided that in case of a grievance, if the person aggrieved is dead or any person unable to act for himself, the complaint may be made, or if it is already made, may be prosecuted by his legal representatives or by any other person who is authorized by him in writing in this behalf. 2, every complaint shall be made in the form of statement supported by an affidavit and in such form and in such manner as may be prescribed. We are not really concerned. 3, this is what we are concerned with, where the Lokayukta or Upalokayukta proposes, after making such preliminary inquiry as he deems fit, to conduct an investigation. So, my lords, now 7, my lords, says matters which may be investigated. Let us say I file a complaint. The complaint can be of 2 forms. It can either be of a grievance or it can be of an allegation. The Lokayukta may say this matter requires investigation under section 9. But 8 specifically says matters which cannot be investigated on a grievance. 9 says, the scheme of the act is so beautiful. 9 says, let us assume whether it is an allegation or a grievance, before you conduct the investigation, I will conduct a preliminary inquiry to see if there is some substance in this. This preliminary inquiry is akin to Lalita Kumari, my lords. In other words, it is akin to Lalita Kumari. Now, while conducting this investigation, my lords, and kindly, my lords, this is all prior to 12.1 or 12.3. What happens at this stage of investigation? One, I have to be put on notice of the complaint itself. Now, if I am put on notice of the complaint, I will probably at that threshold stage itself say that this is foul of 8.1b or 8.1a. I have my opportunity there to say this runs contrary to this. These are matters which are outside the ken of the Lokayukta. Please keep your hands off. But my lords, in this case, what happens? I am not given notice. I am not told of it. They go ahead, give a 12.1 report. After the 12.1 report is given, disciplinary action is initiated against me. I come before this honorable court, get a stay. Criminal prosecution is also initiated. There's an FIR registered. I'm complete in the dark. Now, my lords, 12.3a shall forward. Again, here, my lords, the word is very important. Shall forward a copy of the complaint, and in the case of an investigation initiated, even in the case of a suo motu investigation, even there shall forward by him the opinion recorded by him to be initiated the investigation under 1 or 2, as the case may be, of section 7 to the public servant and the competent authority concerned. 2, shall afford the public servant an opportunity to offer his comments and on such complaint or opinion recorded under 1 and 2 may make such order as to this we are not concerned, my lords. 3a deals with the manner. Now, my lords, in this context, for what fell from my lords, 5 also would become relevant. Subsection 5, 9.5. The Lokayukta or Upayukta may, in his discretion, refuse to investigate or cease to investigate any complaint involving a grievance or an allegation. This is, my lords, the sequitur to the preliminary inquiry. The complaint is frivolous. All these, my lords. Again, this would be, my lords, if the natural justice is complied with. Now, in this case, my lords, if I was put to notice, I could have probably come and told the concerned authority that this is subject matter of 108. These people have a private interest. All these pleas would have been probably been available to me. Now, my lords, kindly see section 12.
So tell us one thing.
Yes.
Nine would not kick in.
Sorry, my lord.
9 would not kick in if 8 gets applicable.
Yes, my lords. Because the threshold bar would get applied.
Threshold. Now, will that mean when the stage 8, section 9 stage has reached, you can still plead what has been contemplated under 8?
Respectfully, yes, my lords. Because 7, my lords, 7 would follow 9. 7, my lords, is the registration of the complaint. I go and place the complaint before the authority. Then, my lords, on that, 9 says, because 9, my lords, is actually a procedural law. Provisions relating to complaints and investigation. 9 would have to be read with the rules. The rules contemplate how it should be filed, in what form. And at that very stage, my lords, 9 would say immediately you would put the accused or the respondent on notice there. Then what happens, my lord? Let us say he doesn't wish to put me on notice. The Upalokakta straight away says there is a bar. Now let us say, my lords, there is another kind of bar under section 8.1a. My lords may kindly have 8.1a, though I'm not concerned with that. If such action relates to any matter specified in the second schedule. So let us assume the Upalokakta, the Lokayukta, says these are matters falling under the second schedule. He will not even proceed under 9. Then he may not even give the complainant notice. He may not even give the accused notice. So, my lords, if that threshold bar, now, my lords, may kindly see what are the provisions under the second schedule. Action taken for the purpose, my lords, national interest, all these, my lords. The second schedule, action taken.
Suppose, in a way, hypothetically, if section 8 has no applicability, let's assume.
Yes.
Then 9, he can go ahead.
9, he can go ahead, but then
Except
still
the fact
9.3 would have to be complied.
Yeah. Except the fact that, according to you, he is required to give you the
Yes.
complaint and seek your reply and then proceed.
Yes. So, my lords, my submissions are twofold, actually. 9.3 operates independently of 8.1b. 9.3, my lord.
So that's what we were asking you. Now, this is important.
Yes.
So observation, what you have said.
Yes.
So when it is an action under 9.3, okay, of 9.3, the objection which is contemplated under 8(1)(b) would not be applicable.
No, my lords, sorry, I don't think I've been very clear, my lords. I'll rephrase it.
No, what, I hope we are clear.
Your lordships are clear. I'm not clear.
8(1)(b) is a threshold bar.
Yes.
Then there is no question to go in 9.
Ye-
There is no question to go in 9. But once this is overcome, or this hurdle, suppose let's assume that the plea of 8(1)(b) is rejected. Let's assume hypothetically rejected. Then it will be only 9. Thereafter it would be 9. In 9, you can't take what is bar under 8.
My lords, most respectfully, no, my lords, that would not be my submission. My lords, 9(3) would give, my lords, 9(3) has two aspects. One is what the authority would do. The authority, after conducting a preliminary inquiry, he may say, I find the bar under 8 applicable.
Well, you can argue,
Yeah.
can argue this. Suppose for a moment, that bar was overlooked of 8(1)(b).
Yes, I can bring it to
That will have
yes.
only under 9, you will convey to him.
I will
Okay, there
convey
is a
to
bar.
him. Yes, my lord. That would grateful, my lord. Now, my lords, may kindly have section 12. Now, my lords, reports of the Lokayukta, etc. If after investigation, my lords, this would become very important. If after investigation of any action involving a grievance, my lords may note this word grievance, because 12(1) is very specific to grievance. So, my lords, now the scheme would be this: the definition of grievance as contemplated under the Act, 7(2) flowing from grievance, complaint flowing from grievance, 9 putting me on notice, investigation, followed by a report under 12(1) if it is a grievance. If it is an allegation, 12(1) won't apply. Only if it is a grievance would 12(1) apply. Now, my lords, if after investigation of any action involving a grievance has been made to the Lokayukta or Upalokayukta, is satisfied that such action is resulted in injustice or undue hardship to the complainant or to any other person, the Lokayukta or an Upalokayukta, by report in writing within 3 months or at any event not later than, this is by way of an amendment, recommend to the competent authority that such injustice or hardship shall be remedied or redressed in such manner and within such time. So, my lord, this action can also cause prejudice to the respondent therein. That is why, my lord, 9(3) becomes very crucial of putting him on notice. One is, my lord, it is remedial in nature, because what Mr. Arbati was arguing on the last occasion. Let us say there is my neighbor's property, there is a building bylaw violation. But let us say, my lord, the officer has, this is a completely hypothetical situation, has been hand in glove. My lord, now he says, yes, you have sanctioned a particular plan encroaching on your neighbor's property. But my lords, the officer would be put to prejudice. It is not something which is not going to cause prejudice to that officer or public servant. Therefore, my lords, even the 9(3) bar would come in of natural justice. Now, my lord, 2, the competent authority to whom the report is sent under subsection shall within 1 month. So we are not concerned with that. 3, now, my lords, kindly note 3. If after investigation of any action involving an allegation. Now, my lords, if this is an allegation, then the bar under 8(1)(b) would not, 8(1) would not apply at all, my lords. I can't take that plea under 8(1). Now, my lords would see at page 122, it is the Lokayukta's own understanding that this was on a complaint, grievance. 122 top, my lords. Report under 12(1). My lords, may kindly have page 122. It is specific that it is a report under 12(1).
That's right.
Why did they say it is under 12(1)? Because it was a grievance of particular employees. It was a grievance. It was their grievance that we were due salaries, whatever A, B, C, D, we were due salaries. They have not given it to us. They have undervalued, sold these properties. Therefore, they filed their grievance with the Lokayukta. They filed the 12(1) report. It is not 12(3). My lords, if it was a 12(3) report, my argument that the bar under 8(1) is applicable would not lie. Because 8.1, my lords, is again very specific to grievance. Coming back to 8.1, my lords. 8.1 reads, except as hereinafter provided, the locator shall not conduct any investigation under this act in case involving a grievance. It doesn't say complaint. My lords, actually the legislature is so careful. They say complaint involving a grievance. They don't, otherwise they would have just stopped at complaint. Complaint involving a grievance. 12.3 says allegation. 12.1 says grievance. Therefore, my lords, by their very own report, my lords, 8.1 would be applicable.
Okay.
Then, my lords, if the then my lords 5 says what happens thereafter. Not concerned. Then, my lords, if I may request my lords to come back to my note. My lords, I'll just place the scheme of the act from my note very quickly now. My lords, has my note, my lords. The scheme of the act, relevant definitions, action, allegation, grievance, maladministration. Section 7 of the act deals with matters which may be investigated by the Lokaयुಕ್ta and Upalokaयुಕ್ta. The Upalokaयुಕ್ta exercises powers under 7.2. This power is exercised only on a complaint. The investigation pertains to either grievance or allegation on a complaint. Section 8 specifically enumerates matters which shall not be subject to investigation. Section 8.1 specifically deals with grievances. The present case concerns Section 8.1b. Section 9 pertains to provisions relating to complaints and investigations. Before embarking on an investigation, the Lokaयुಕ್ta or Upalokaयुಕ್ta shall cause a preliminary inquiry to ascertain whether the further investigation is required. Subsection 3 of Section 9 expressly provides for the principles of natural justice to be complied at the investigation stage. This includes making available a copy of the complaint and hearing the public servant. Evidence for investigation is collected under Section 11 of the Act. 12. Reports of the Lokaयुಕ್ta or Upalokaयुಕ್ta. Reports under sections can be furnished only after investigation. Subsection 1 pertains to reports made after an investigation involving grievance, which we are concerned with. Likewise, subsection 3 pertains to reports made after an investigation involving an allegation. Now, my lords, my contentions would be this. 1. Before the Upalokaयुಕ್ta submitted the report under section 12.1, a copy of the complaint was not served on the petitioners, nor was there any opportunity of being heard. The petitioners herein were specifically arrayed as respondents in the complaint, and all allegations in the report pertain to the petitioners herein. Now, my lords, if my lords may kindly have page 122. Para 1, about 4 lines from the bottom of para 1. Herein after referred to as respondent 1 and respondent 2 in respect of malpractices committed by them in the auction sale pertaining to the assets. Specific. Again, para 6 at 126.
No, they are narrating what is the nature of complaint.
No, my lord, specific allegations to these respondents.
Right.
Yes, yes.
Right? The allegations are specific. By naming you, let's assume. What is being argued is what has been recommended is different. Next.
Then, my lords.
In what he says is a general recommendation without naming anyone. That's the argument.
My lords, the general recommendations, though it in the recommendations it doesn't name me, has led to specific action against me.
Pardon?
The general recommendations has led to specific actions. That is the criminal proceedings and suspension, which has been stayed by this court. Now, my lords, in my note, my lords, point number 3. Para 3 of the report reveals that the DC Davangere and the Superintendent of Police conducted the investigation, and on the directions of the Upalokaयुಕ್ta, the petitioners were in the dark of all the proceedings. Now, my lords, the judgments that I would be relying. Madam, Court of Karnataka. Give my copy. Give the other side. My copy. Yeah. Give other side. My lords, actually the first judgment, my lords, though it is of a learned single judge. My lords, the reason why I am placing the first judgment of Gundappa, though it is of a learned single judge, my lords, the act came into force in 84. In 89 was this judgment, and all subsequent judgments have in fact rephrased what was said in this judgment. But this judgment captures it rather beautifully, my lords. My lords may kindly have report the compilation page 4, para 6. In light of the aforesaid, my lords has that.
Yes.
Para 6. In light of the aforesaid contentions, the following points arise for consideration. 1. What is the scope and ambit of Section 9 of the Act? 2. Whether the provisions of subsection 3 of Section 9 are mandatory, and whether the provisions of Section 9 of the Act are attracted in the case on hand, and if so, whether the provisions of subsection 3 of Section 9 of the Act are complied with. 4. I would skip, my lords. Thereafter, my lords may kindly have page 7, para 8. My lords, 8, 9, and 10 are relevant. My lords, I'll just place this judgment in extension of the other judgments I will go through quickly, my lords. I won't repeat it in the other judgments. Para 8. The aforesaid Gundappa.
Filed appeal also, it's also reported.
Yes.
Pardon?
Confirm.
In appeal, Gundappa is also.
Confirm.
Confirm.
There are report, both are reported.
Yes.
Grateful. The aforesaid provisions of Section 9 of the Act for the purpose of considering the scope and ambit of the said section can conveniently be divided into 4 parts. Subsection 1 and 2 can be grouped in the first part. Subsections 5 and 6 can be grouped in the second part. Subsections 3 and 4 can be grouped in the third part, and subsection 7 forms the fourth part. Under subsection 1 and 2, my lord, subsection 1 and 2 is procedural in nature. 1 and 2, any person may make a complaint to the Lokayukta or Upalokaayukta under and subject to the provisions of the Act. The complaint has to be made in the form prescribed by the rules, and it shall have to be in the form of a statement supported by an affidavit. As the complaint has to be made with, under, and subject to the provisions of the Act, it shall have to relate to the matters which are permissible to be investigated by the Lokayukta or Upalokaayukta. The Lokayukta or Upalokaayukta has to act and exercise powers within the parameters of the Act. Therefore, the complaint shall relate to a grievance or an allegation as defined under subsections 2 and 8 of Section 2 of the Act. According to subsection 2, my lords, I'll skip the definitions. At page 8, I'll skip the definitions, my lords. According to Section 2(8), grievance means a claim by a person so and so. I'll skip that. Thereafter, the second part relates to a preliminary inquiry for the purpose of finding out whether the complaint to be investigated by the Lokayukta or Upalokaayukta. My lords, may only note there has been one change. After 2020 amendment, a time frame has been given for this preliminary inquiry in 3A. This part, as already pointed out above, is covered under subsections 5 and 6. According to subsection 5, the Lokayukta or Upalokaayukta may, in his discretion, refuse to investigate or cease to investigate any complaint involving a grievance or an allegation if in his opinion the complaint is frivolous, vexatious, or is not made in good faith, or if there are sufficient grounds for investigating or for continuing the investigation, or other remedies are available to the complainant, and in the circumstances of the case, it would be more proper for the complainant to avail such remedies. Thus, the preliminary stage enables the Lokayukta or the Upalokaayukta to find out whether the complaint involves a grievance or an allegation which should or should not be investigated. The criteria for exercising the discretion by the Lokayukta or Upalokaayukta to investigate or refuse to investigate or cease to investigate any complaint involving a grievance or an allegation are laid down in subsection 5. On the basis of the guidelines laid out in clauses A, B, and C of the subsection of Section 9, the Lokayukta or Upalokaayukta has to decide at the stage of preliminary inquiry as to whether the complaint should or should not be investigated. If the Lokayukta or Upalokaayukta, as the case may be, decides not to entertain the complaint or to discontinue investigation in respect of a complaint, he shall have to record reasons thereof and communicate the same to the complainant and the public servant. Even in this stage, my lords, kindly note this, even in this stage, the public servant has to be informed. Even if you are binning it at the threshold, you should inform the public servant. As subsection 5 is intended to safeguard the interest of the public servant concerned and to protect him from frivolous or vexatious complaints or complaints made not in good faith or for any other reasons mentioned in subclause B and C of subsection 5 of section 9, in all the more necessary for the locator, as the case may be, to closely scrutinize the complaint involving a grievance or an allegation at the stage of preliminary inquiry before he decides to conduct investigation into the complaint. Subsection 6 also safeguards the interest of the complainant in as much as it makes it obligatory on the part of the locator or upalocator, as the case may be, to record his reasons for refusing to entertain the complaint or to discontinue any investigation in respect of a complaint and communicate the same to the complainant and also the public servant concerned. Thereby, it enables the complainant to know the reasons of the locator or upalocator, as the case may be, for not entertaining the complaint and for discontinuing any investigation in respect of complaint and to pursue its further remedies. Now, my lords, we are really concerned with this, what the learned judge calls the third part. The third part, which is actually the third stage of the complaint filed before the lokaayukta or the upalokaayukta, as the case may be, relates to conducting of an investigation into the complaint. Where the lokaayukta or upalokaayukta decides to conduct any investigation into the complaint made by him as per clause A or B of subsection 3, he shall have to forward a copy of the complaint to the public servant and the competent authority concerned and afford to such public servant an opportunity to offer his comments on such complaint. Clause C therefore only directs the lokaayukta or upalokaayukta to make an order as to the safe custody of the documents relevant to the investigation as he deems fit. Subsection 4 is subject to subsection 3 because it opens with the word save as aforesaid. Subject to subsection 3, subsection 4 gives the discretion to the lokaayukta or upalokaayukta, as the case may be, to follow the procedure for conducting investigation whether in public or in camera as deemed necessary. My lords, we are really again not concerned with the next para that deals with subsection 7. My lords, may come to para 9. The point for consideration is whether subsection 3 is mandatory or discretionary. It is relevant to notice that on the basis of the investigation conducted by the lokaayukta or upalokaayukta, as the case may be, into the complaint made before him involving a grievance or an allegation, he has to make a report under section 12 of the act to the competent authority. If satisfied, can also make a declaration in his report as per subsection 1 of section 13 and hold the public servant should not continue to hold the post held by him. This, my lords, is actually something parallel to 12. This is the 13 proceeding, like how 13 and 14, this is parallel to 12. The competent authority is required to take action within the period prescribed in section 12 and intimate the lokaayukta the action taken or proposed to be taken on the report. If the lokaayukta or upalokaayukta, as the case may be, is not satisfied with the intimation regarding the action taken on the or proposed to be taken by the, it is open to him to make a special report upon the case to the governor and also inform the competent authority concerned of the complaint under subsection 5 of section 12. Therefore, my lords may note this, therefore it is clear that investigation into a complaint and the report made by the investigation into a complaint by the lokaayukta to the competent authority will have a serious impact on the public officer concerned. It will affect his service and very seriously as the competent authority has to examine the report to the lokaayukta, forwarded to the lokaayukta with the period stipulated under section 12. If a declaration is made in the report in terms of 13(1) of the Act and on acceptance of the same, the competent authority under the public officer will have to be placed under such. That being so, the lokaayukta or the upalokaayukta, as the case may be, is required to follow the procedure laid down in subsection 3 of section 9. It is not open to the lokaayukta or the upalokaayukta, as the case may be, to disregard or overlook clause A and clause B of subsection 3 of section 9. The procedure laid down in clause A and B for conducting investigation in a complaint is required to be followed scrupulously, and it is essential to the validity of the report made by the lokaayukta or upalokaayukta, as the case may be. When a statute is passed for the purpose of enabling something to be done and prescribes the formalities which are to be attended, its performance, those prescribed formalities which are essential to the validity of the thing when done are called imperative or absolute. But those which are not essential may be disregarded without invalidating the thing to so and so. My lord, this follows the famous. Therefore, my lord, The statute, if it has to be done in a particular manner, it has to be done in the particular manner. Natural justice forms one of them. Thereafter, my lords, may I have the next judgment I am relying on. My lords, that is the judgment of Yediyurappa, which begins at compilation page 17. My lords, may only note the relevant paras. Para 13 at page compilation page 63. The questions were framed in para 13. We are really concerned with question 3.4, which 13.4, which is at page 64. Then my lords may kindly have paras 26 onwards, which begins at compilation page 73 at 74 foot of the page. My lords, this was the case, my lords. In Yediyurappa's case, it was a case where it was suo motu. It was exercising powers under 7.2a. It was not under a complaint. Now, my lords, kindly see the contention there, 74 foot of the page. Since the petitioner has urged that even in cases referred under section 7.2a of the Lokayukta Act should have been complied with clauses A and B of subsection 3 of section 9, it is useful to excerpt the same for immediate purpose. I would skip that. Then, my lords, para 27. I'm in fact grateful to what learned senior counsel Mr. Bhagwat said, my lord, because this is a case where Gundappa, they observe Gundappa has been confirmed. At page 76, para 27. My lord has that minute. Now, my lords, page 76, para 27, in the decision in Gundappa, it was held that the which I just placed before my lords, Lokayukta Kwasaj and the authority shall follow the rules of natural justice. Therefore, it was necessary for the Lokayukta to send a copy of the complaint to the petitioner and the competent authority and afford an opportunity to the petitioner to offer his comments on the said complaint. Thus, it was held that clauses A and B of section 3 of section 9 are to be complied with in the manner provided. The decision of the learned single judge was confirmed by the division bench of this court. The division bench has held that having regard to the serious consequences contemplated under section 13 and 14 of the Act, provisions of clause A and B of subsection 3 of 7 have to be complied with. Now, my lords, I'm just putting a question to myself, following what my lords put to me. Now, my lords said, what if criminal prosecution was started under 14? Let me assume it is under 14. Even then, my lords, this judgment says, since serious consequences follow, the principles of natural justice had to be complied with.
Yes.
Thereafter, my lords, I won't read 28. My lords may mark 28. I won't place it in extension. 29. Well, this sets down the narrow scope which my lords could consider. It is only not whether the decision-making process was correct. My lords is in fact not seeing the decision itself. Whether the decision-making process was contemplated, that is dealt with in 29. At 78, my lords, about the second line, but I'll place 29 in its entirety, my lords. My lords permits me. 77. The Lokayukta being a quasi-judicial authority, his decision should be reasoned. The writ of certiorari will lie to set aside the decisions made in violation of the principles of natural justice when important rights of the parties of far-reaching consequences are adjudicated in a summary fashion without giving a personal hearing, where proposals and counter-proposals are required to be examined. Otherwise, it would directly destructive of judicial propriety and fair play. The catena of decision cited by the learned counsels of the petitioner on the point of violation of principle of natural justice supports the case of the petitioner. The contention of the respondent Lokayukta that he has not given any direction for the petitioner to vacate his office and therefore question of giving him an opportunity of hearing. My lords, this was one of the very contentions raised by my learned senior friend, my lords. This was, I'll just place this again. The catena of decision cited by the learned counsel for the petitioner on the point of violation of the principles of natural justice supports the case of the petitioner. The contention of the respondent Lokayukta that he has not given any direction for the petitioner to vacate his office and therefore the question of giving him an opportunity of hearing the petitioner did not arise holds no water, as the petitioner was the so-and-so, when the report was leaked through media as to his indictment and lot of dust was created in the political circle and no moral ground for the resigned as so-and-so. He was condemned unheard. In a nutshell, there is no material placed on record to establish that the petitioner has shown any official favor to the companies. This is on those facts. Thereafter, my lords, para 31. On a careful examination of the case of the petitioner, the statement of objections and decisions cited by the counsel, the learned senior counsel for the petitioner, learned senior counsel BR of the considered view that the petitioner was condemned unheard and there was flagrant violation of the principle of natural justice, fairness in administrative action and the statutory provisions. The decision cited by learned so and so, I'll skip that, my lord. Then, my lords, the next decision is, my lords, the decision in Kumarswamy Minerals. Again, I won't place that, my lords, in thing. I will just flag the relevant para 15 onwards. It begins at page 81. My lords, very, very interesting here, my lords. Actually, all these decisions that now, though, my lords, my submission as a counsel, my lords, I would probably urge these judgments would require, though it is in my favor, I would say this probably lays down bad law for the simple reason these were cases under 12.3. Though it was under 12.3, they gave the benefit of 8.1b. I'm using it today to my favor, but I'm saying, my lords, only if it is under 12.1 could the benefit under 8.1 be given. But, my lords, the court there said, though it was a report under 12.3, they gave the benefit.
Still they gave the benefit.
Still they gave the, which according to me, my lords, may require reconsideration. But
yes.
Now, my lords, 81. Sorry. Okay. And I will finish it. My lords, I'll just place this 81. My lords may have a relevant, my lords, at para 15. That is at 94. 94, my lords. The questions were framed.
Yes.
In like continue,
which para
should
you
I
said?
continue after lunch, my lords?
Para which para?
Para 15.
Yes.
In light of the, because this was a case where the report was under 12.3. In light of the aforesaid facts and the rival contentions, the points that arise for our consideration are, my lords, has it? Whether the complaint filed by the third respondent is not maintainable in view of 8.1b and 8.2c of the Lokayukta Act. Whether the report submitted by the Lokayukta under 12.1 and 12.3 of the Lokayukta Act and the action initiated by the state government are liable to be quashed. Now, my lords, they extract the provision. Now, my lords has page 97, compilation page 97. About 10 lines from the bottom, my lords.
Yes.
If the complaint, my lords, has that.
Yes.
If the complaint falls under any of the clauses mentioned in the 8.1a, b and c, they shall not conduct any investigation. Similarly, if the case falls under 8.2a, b, c and d, then also they shall not investigate. In fact, subsection 3 of section 8 imposes restriction on the power of the Lokayukta in respect of complaint involving a grievance to question the administrative action involving the exercise of discretion, except where he is satisfied that the elements involved in the exercise of the discretion are absent to such an extent that the discretion can prima facie be regarded as having been improperly exercised. In the words of an administrator involving discretion as a rule, they shall not entertain the complaint involving the grievance. However, if the discretion is improperly exercised, then only they get jurisdiction to entertain such complaint. After going through the complaint, they are at liberty to make such preliminary inquiry as they deem fit to conduct any investigation under the Act. In the course of such investigation, my lords, this is paraphrasing Gundappa, my lords, if I may say respectfully. Then, para 18.
Yes.
As is clear from 8.1b, read with 9.5c of the Lokayukta, if the complaint involving a grievance or an allegation has or had the remedy by way of an appeal, revision, review, or any other proceedings before any tribunal, court, or other authority and has not availed the same, then they shall refuse to investigate or cease to investigate such complaint because by virtue of 8.1, they have no jurisdiction to investigate such grievance. Then, my lord, the judgment of S.N. Hegde is quoted, 19. at compilation page 102. Now, my lords, I'm placing para 19 and I'll make good my
Yes.
Now, my lords, I will place para 19 and make good my submission so far as respondent number 6, because he availed the remedy of filing a PIL. My lords, there is another subsequent judgment of Dharmasthala Institute, which I will place. They say that in such case, you have already availed another alternative remedy or complaint before the Lokayukta is not maintainable. They extract Kumaraswamy minerals and say,
What is remedy is contemplated in the nature of an appeal, review
Yes.
or revision?
I follow, my lords.
Ah,
But my lords, in fact, this court in a judgment, my lords, which I have cited at item 6, extends that even to a PIL. It is by virtue of this judgment, but otherwise, I think
see, remedy is,
I follow.
it's something which is personal to that litigant.
Follow.
Litigant in the sense, because the words used are appeal. Let's prima facie view.
I follow.
We'll see the judgment.
I follow. 19, my lords, therefore, at 102, compilation page 102, therefore, it is clear that the words used in 8 of the Act shall not conduct any investigation if the case falls under 8(1)(a), B, C, or if the case falls under 8(2), so and so. The said provision is mandatory. Unless the Lokayukta or Upalokayukta has jurisdiction to investigate under the Act, any such investigation to be conducted would be invalid, void, and without authority. It was contended on behalf of the Lokayukta that 8(1)(b) of the law applies to cases where the complainant has not availed all the remedies available to him under law. It has no application to the case where the complainant has availed the remedy. If the complainant has availed the remedy and if he is not successful in retrieving a grievance in those proceedings, the question of the complainant approaching the Lokayukta would not arise, as his complaint and grievance has been already adjudicated by the authority which is competent to adjudicate the same. Thereafter, my lords, may have the, I'll just place this judgment for the lunch recess, my lords. It's a short thing at 113. Again, another division bench decision at 113.
Yes.
My lords, 113. I'll just place this. It's a small judgment, my lords. Only one para. 2 paras from this. 113. My lords, para 1, the investigation report dated 6/5 issued by the Karnataka Upalokayukta under 12(3) of the Lokayukta Act and order dated passed by the entrusting the inquiry in respect of the allegations are called in question in these proceedings.
Yes.
Now, my lords, may kindly see what they do at para 7. A bare reading of 8 at 115, compilation page 115. A bare reading of 8(1) of the Karnataka Lokayukta Act makes it crystal clear that in case of a complaint has or had any remedy by way of an appeal, revision, review, or other proceedings before any tribunal or, and has not availed of the same, it is not open for the to conduct investigation under such act. My lords, this was actually a case of an allegation. Despite that, my lords, they extended the benefit of 8(1)(b), which may not hold good, my lords.
Yes. That's all. Anything else?
Then, my lords, the next judgment, my lords may only mark para 29 and 30. It's a single judge. I will not place it. My lords may only mark para 29 and 30.
Okay.
My lords, then my lords, if I may continue for about 15 minutes after lunch, my lords.
You come back after lunch.
Lord's permission.
Punacha.
Dhyan, Chinnappa.
Sorry, my mistake.
Punacha has become a judge, my lord, now, so.
I'm getting into that habit. Yes.
Lord,
I think the
serial
fault
number-
lies with me, my lords. I've taken too much time.
Since
Yes, Mr.
serial number 14, my lord, your lordship have it another day, my lord, I think. Gautam seems to be occupying your lordship's time.
Who is the other side?
I informed him.
DML, no?
I'll call him and tell him.
Just say re-notify.
My lords, yes.
Judicial officers, seniority at least.
That's right. We will just take up that. There was some mentioning made, Mr. Bhagwat. We just wanted to, otherwise we could have discharged the board, but we don't want that, that gets collapsed and we don't have anything.
Yes.
My lords,
Don't
may I
want that.
submit, my lord? Today morning I have submitted list number 2, my lord. It's serial number 2, my lord. It was supposed to be list number 1, my lord. By mistake, I have mentioned the list number 2. It is list number 1, my lord.
What did you mention and what did we do, ma'am?
It is to be listed tomorrow, my lord. It's list number 1, my lord. By mistake, I have told list number 2.
We don't know. We have listed list number 2 tomorrow.
It is in the month of November, my lord. The list number 2 matter, list number 1 matter.
So it's not list number 2, item 2. It is not.
Yes, my lord. It is list number 1, item number 2, my lord. By mistake, I have mentioned the list number 2, my lord.
Yes. Now, these are objections there.
I will comply it, my lord.
We have given a date.
Lord, it is in the month, there is the threat of demolition, my lord. It's a BDA matter. Special bench has been constituted. Justice Krishna Dikshit.
Oh, this is that matter we have given tomorrow, thinking that 20
No,
is the.
by mistake, I have told list number 2, my lord. It is list number 1, my lord.
Is the date in huh? It has gone to 4/11.
Yes, my lord, that is mine. That's why I'm requesting, my.
So this need to be listed before that bench.
Yes, its sitting is on 20th, my lord. This month, 20th.
This. Check up with the registry. But anyone was present the other side. In this one. We passed over. We'll have it tomorrow.
Please, ma'am.
In your man, okay?
Please.
We'll have it, we'll come back after lunch. Mr. Chinnappa, who is the other side?
Mr. Nayak, my lord.
Where is he?
He's not
He's
here.
there. We will.
You are opposing the adjournment.
You are opposing? So you have to wait.
Excuse me. Serial number 7, sir, list 2. My personal presence was come today, sir. Lakundi case.
Which
Raghunath
matter?
Mandir.
Is it list 2 or list 1?
List 2, sir, contempt court. Raghunath Mantri, sir, last.
Your presence was asked
Yes,
for.
sir. Yes, sir.
Just see the last order. We have the file. Just show us.
I have some difficulty in the afternoon today.
Let's see that. Let's see that. What is the difficulty? Who is the counsel? Where is the counsel?
He said he's opposing this. If it's.
This is on that pay aspect, na?
Yes, ma'am. That actually has to be decided under 33C. And there's been now 3 orders right up to the Supreme Court.
But tell us one thing.
Yes.
On an issue of equal pay for equal work. That's what has been allowed in their favor.
That's true, my lord. As a matter of fact, this was part of a contempt proceeding. In the contempt proceeding, it was dropped on that very ground. That this has specifically been dealt with in the contempt proceedings. And it was dropped. After that, they go and file a complaint saying now initiate prosecution.
We will see that. He has a difficulty, just ask him.
Have some next week. Anytime next week.
Just give a date in this matter where Mr. Chinnappa is appearing.
26th. Would 26th be acceptable? 26th?
Yeah, whatever is date convenient. Not an issue.
Right, I'm great.
This, we have given in this matter. Tomorrow's date. Give PIL. This is what was. We have given in this matter. Huh? Yeah. Just ask, mark his presence. This is in which court? This is in court. Just mark his presence. Just mark his.
I'm great.
But.
Good.
Court officer. Court officer.
For pronouncement, serial number 32, Shri Latif, Government Advocate.
Order, writ petition is allowed. The order of detention dated 19/3/2024, passed by respondent number 2 bearing number MAG 1/3 2024, subsequent approval order dated 26/3/2024 and confirmation order dated 22/4/2024, passed by respondent number 1 stand quashed. Consequently, the respondents are directed to set the detainee at liberty forthwith. However, registry is directed to communicate this order to the respondents as well as the jail authorities to release the detainee forthwith in case he is not needed in any other case.
Is detained in Central Jail at Bangalore. Please.
Yes.
33, serial number 33, Shri M.A. Appaya.
I have one submission, my lord. In complete for respondent. This is a case where your lordship heard last occasion. And this is the order sheet. The registry of this court, lord, is directed to produce certain records regarding the statement made in third rejoined. But is supported by lord knows clear strength notification. They cannot give just, it should be reflected in the seniority list. But is supported by clear strength notification in the matter of seniority. Just like lord, they cannot say. In the reply statement filed by the registry, my lord, para 34, they say, my lord, seniority is prepared based on the date of entry into service bar date of promotion. It is a clear admission made by them. It is also noted by one single judge held, my lord. It is not a seniority list at all.
You want? Yes, which is your repeat. Not tag, but each year.
23.
But apart from that, no, because they are not compared office objection, probably. There is 1 year.
You don't understand the logic of tagging it when the appeal is lying under objection. Tell us one thing. Do that. Who is preventing you? Do that and then mention it. We'll do it. Do it. Okay. Now what do you want in this? What do you want? You want to argue the matter? Last time was direction. Yeah, who is appearing for the High Court? See, they will produce the record, there is no issue, unless you argue, how would you take it forward? For the request of violation for the appellants in which again. 162 of 2023 being notified.
But there's a interim or running against me, against the private respondent. Stay of the interim judgment itself.
So what is the effect? There are no promotions.
Not that, court said seniority is quashed, redo the seniority in accordance with law.
Just fix it, just we will have it immediately after this Dasara.
I will to the court. I cannot.
Before that, it will not be.
My lord's court is overboarded. I cannot say anything.
Every court is like that, Mr. Rao. Just keep it after vacation. See, with an understanding, you must start.
It was understanding last occasion. Today at 2:30, they will.
They are ready.
Short question is that not. Para 34, they admit. Sir, admission is made by them. Can they improve in thorough rejoinder or not? The statement.
See, we will not give you any adjournment on the next day. It's not, we'll argue the matter.
But private respondents, none of them have not contested the matter. It is recorded in the writ petition.
Sir, 2810. No, sir. Sorry, sir. 2910, sir. 2910.
ಮುಂದಿನ ತಿಂಗಳ 29.
My request only is not to take further adjournment on that part.
2:30 ಕೇಳಿ sir.
My request is not to take further adjournment on the day. That's all, nothing else. I need to report. I don't.
2910, sir.
No further adjournment will be granted. The next date of it. Yes.
Same minute, 2:30, same date. 2:30.
Serial number 18.
You appeared in the morning. You appeared. You were saying this morning, yesterday,
Yes, sir. Yes, sir.
petition is pending before the last.
Please, ma'am.
So what you said that why should the appeal be, pending here? We have stated, what is your difficulty if we say that the interim order will continue till the.
Malats, Malats, it is settled position that Malats, compensation can be granted, Malats.
Please, according to you.
Please, Malats, I'll produce the judgments, Malats.
What you say is what the judge has said is not, is justified.
Yes, ma'am.
And there is no interim prayer also in the writ petition, my lord. There is no interim prayer in the writ petition itself. No. They never sought any interim.
What she is saying is, there is no dispute that, the compensation need to be granted. Then you have any.
No, what has happened, my lord? The learned signature relied upon.
I'll convince Malats with respect to the Ekara.
See the issue, then let the state continue and let the single judge decide. But single judge, the direction of the single judge is insofar as A is concerned, that has been allowed in your favor.
Yes.
That has been allowed.
Because.
So even we are saying, it.
Yes, but the reason is this, my lord. Now they received the compensation in the 2015 or 16 by consent. After 4 or 5 years, they come up with a play that that is the when accepted by a consent. Suppose they are entitled, they could not accept that on that day itself.
Okay, sir.
Please, I'll file it.
Serial number 12.
May it please your lordships. My lords, if I may request my lords to have my note, my lords. I'll wind up in about 10 to 15 minutes, my lords, less than 10 to 15.
Before one submission, I filed the impleading application and clarification of the interim order, my lord. Today I filed the application. Which matter? Present matter.
He represents, my lord, a group of employees
Employee.
whose salaries apparently have not been paid. So my learned friend would say that he has filed the impleading application today and also another application.
Filed it, it come, is there. Yes, now is filed, my lord.
In fact, my lords, I can't have any.
Yes.
My lords, if my lords may have my note, my lords. After contentions, I have placed point A, principles of natural justice violated. I have placed it before my lords. My lords, I have already placed point A of my contention, 3A, 3B, my lords. If my lords may have 3B. The complaint is a grievance bar to investigate under 81B. On perusal of 12.1, the report, it can be seen that the complaint, my lords, that would be unnumbered page 4, my lords. Sorry, my lords, I don't have page numbers. On a perusal of the section 12.1 report, it can be seen that the complaints are the Bhadra Cooperative Sugar Factory, labor and employee. They have a personal grievance. A report under 12.1 can be filed only if the complaint was in the form of a grievance. 3. In WP, my lords, this is slightly irrelevant. In WP 10041 of 2017, the petitioner therein, Gyanbagh Sugar Developers, claiming to be a lessee of Bhadra Sakari Sakrin Karkhane Niyamata, challenged the auction proceedings dated 27/1/2017. This honorable court, noticing the scope and ambit of the pending revision proceedings under 108 concerning the very same list, directed that all issues be decided in the said proceedings. This would directly answer my lord's question, because my lords put to me, who can go before the 108 authority? Now, if my lords may kindly have page 110 of my paper book. My lords may kindly have 110.
Yes.
In the paper book, my lords, 110. My lords, relevant would be, my lords, at 117. Para 4, my lords, the very same list, 117, the present petitioner, Gyanbagh Sugars and Developers and respondent number 2 are aggrieved by the auction of assets of the said sugar factory in question, which according to them is for a far lower price of 54 crores, though the market value of the assets are much higher. The very same subject matter of the complaint that is pending. Thereafter, my lords, this honorable court held in para 6, section at 118, Section 108 of the Karnataka Cooperative gives comprehensive powers to the state government to pass appropriate orders in such matters after such inquiry as it deems fit. Thereafter, my lords, they extract 108. After hearing para 8, after hearing the learned counsels for the parties for some time, the court is of the opinion that since the state government is already seized of the matter in the aforesaid revision petition filed by Bhadra, so and so, therefore the present petitioner, that is the lessee, can also be heard by the state government in the matter, and this court finds no useful purpose served if different forums, courts, or tribunals hear the same or similar grievance in the matter arising out of the same cause of action, namely the lease of the sugar factory in question, defaulting in payment of loans by them, and the consequent action happening under the provisions of the law. Since the state government is admittedly seized of the matter in revision petition number 5 of 17, which the learned counsels at the bar informed the court is coming up for hearing, so then therefore, my lords, they said so far as the lessee is concerned also, your very same grievance, please agitate before the revisional authority. That would take care of this, my lord. Then the last point, my lords, that I'm maintaining, that is the bona fides of the complainant. If my lords may kindly have page 101 of the paper book. My lords may kindly see number 4 at page 102. He is my lords respondent number 7 today before my lords, who was the original complainant before the Lokayukta. Respondent 6 and 7, my lords, has petitioner 4. My lords, this petition, my lords, which was again, my lords may kindly see at page 103, foot of 103. The writ petition is filed under 226, 227, praying to quash the sale proceedings conducted by the respondent number 3 authority in favor of respondent number 8. The very same challenge. There, my lords, he decides not to prosecute it. Now, my lords, what is the sequitur, my lords? Why did I place this judgment? Now, if my lords may kindly have item number 6 in my judgment compilation at page 167. My lords may kindly have para 9, which is at 174. Again, a division bench decision, my lords, 167 at 174. Para 9. Meanwhile, my lords, says that. Meanwhile, the 4th respondent has also filed a public interest litigation in WP so-and-so before this court. The 4th respondent in the said writ petition paid for directions to initiate action against the society and its principals for further directions, including a direction to the authorities to conclude that the society was not entitled for the benefits under the so-and-so. This court dismissed the writ petition as withdrawn on 9/6/2015. In this case, it was not prosecuted. Thereafter, my lords may kindly have para 15 at page 180, sorry, 180. It is undisputed, my lord says that 180 para 15. It is undisputed that the 4th respondent filed a PIL in WP so-and-so before this court. The writ petition was for directions to the state government to initiate action against the society, its principals, and for further directions, including a direction to the authorities to conclude that the society was not entitled for the benefits. It is also undisputed that the assertions in such writ petitions were similar to the allegations in the complaint with the Lokayukta. This writ petition is dismissed as withdrawn on so-and-so. Thereafter, my lords, their lordships therein extract the judgment of Kumaraswamy Minerals, which I had already placed before my lords, which begins at 181 and goes on till 183. Then 183 foot. This exposition would apply to the present case. As such, the Lokayukta, in view of the prohibition under 8(1)(b) could not have dealt with by the 4th respondent complainant after the 4th respondent had filed WP so-and-so. In this case, my lords, respondent number 7 had filed it. Relying on Kumaraswamy's decision, my lords, Kumaraswamy Minerals. My lords, the findings of the judgment which is relied upon is at 103 of the compilation, which I had placed. He has availed it. My lords, though, my lords, it was not decided on merit, but the subsequent judgment interprets it to say that that is also availing of a remedy. That is the interpretation given by this court. I'll leave it. I won't press it beyond a point, but I'll leave it at that. I just want to place it. My lords, now, my lords, just 2 more pages on facts, which I would want to show my lords. If my lords may kindly have page 83. My lords, now what is the specific? I just ask myself, what is the specific allegation against me? Because my lords, though my lords, it is only the decision-making process that is questioned before your lordships today. My lords, only to satisfy the court, I need to place what is actually the allegation. The allegation is petitioner number 1, who was the sales officer, conducted the auction and sold the assets of the sugar factory at a far lower price. Petitioner number 2, under the scheme of the Cooperative Societies Act, he authorized petitioner number 1 And both of them were hand in glove with the bid purchaser, that is the successful bidder. Now, my lords, kindly see what petitioner number 1 does, which is the action. My lords, this is the action which is subject matter of complaint, which translated copy is at page 83. My lords, may I kindly have 83? There were 4 bidders, my lords. Finally, he gave it to this one person. And the auction sale is not confirmed. My lords, may kindly bear this in mind. Now, my lords, at 85. Last para, my lords, I'll just place the last para. The liability of Bhadra Cooperative Sugar Factory as on 31/3 is 100 crores, and the value of the movable and immovable properties of the said factory is 76 crores. Equivalent to these two amounts or for more, none of the bidders have come forward for a higher amount. Hence, in this regard, the opinion, my lords may kindly notice, the opinion of group banks, that is Davangere DC, there were 5 consortium banks. The group banks is to be obtained. On this background, either to accept the bid or reject the same resolution which is reserved. That 15 days time is required, so and so. Thereafter, my lord, there's only one document. My lords, my apologies. This is in the vernacular. I'll have it translated on Madam Court Officer. 27/1/2017 was the action which is complaint. The action is the option. After that, my lords, internal page 29, my lords, I won't read it because it's in the vernacular. I won't read it, my lords. At internal page 29 there, it says the consent of all the consortium banks were obtained. Therefore, after the consortium banks consent was obtained, only then, even if at all the confirmation has to happen, it is not the sales officer or but my lords, that is on merits. Today, my lords is really not concerned with the merits. But that is it, my lords. The only allegation is that I have been in hand in glove and auctioned it at a lesser price. Grateful for a patient hearing. My lords, yes. My lords, it was served to me now, my lords. But in fact, I can't have a grievance with that because that is my very case. Let the revision petition 5 of 17, which is pending before the revisional authority.
Lords, I have filed an application, 2 applications filed by me, Milord. One seeking
One,
impediment.
I got one.
Yes, both are.
Oh,
And the other one, Milord, seeking clarification, impleading myself as a respect. I am, Milords, one of the employee, Milords, of the factory, Milord, sugar factory, which whose property, Milords, is a subject, auction of which is the subject matter of this petition and the 12-1 report, Milords. We, Milords, independently pursued our remedy, Milords. We made before the state, Milords, and we made our representations to the state. And when the state has not considered it, we approached this honorable court, Milords. A single judge of this honorable court has allowed our writ petition and directed the state to consider our representation. The state did not act. We moved a contempt law. In the contempt, they came up, they issued an endorsement stating that because of the pendency of the present writ petition 9000 of 2020 and the interim order in this case, Milords, our prayer cannot be considered. Our request is only this: whenever such sugar factories, Milords, another one is, Milord, seeking a clarification from this honorable court that the interim order passed in this Milord's writ petition will not come in the way of state taking action in respect of, Milord's, the auction which is the subject matter, that whether it's right or wrong is pending before the state, Milords. State taking action on that, or Milords, plotting a scheme. My only concern is the interim order, Milords. State is sheltering under the interim order passed by this honorable court. Interim order, Milords, Lordships were pleased to, Milords, stay the 12-1 report and further proceedings thereon. At his behest, yes, Milord. At his behest.
Not the revision.
And FIR in further proceedings.
12-1 and further proceedings emanating thereof, which would be the FIR and the thing, not the revisional proceedings. But my lords, actually, this is my entire contention. Please hear the revisional proceedings. So I can't have a,
My only concern is this, my lords, in my application I have produced the endorsement issued by state. State is not proceeding further. Because this case is pending and interim order is there in this. Unless state proceeds further and takes a call on that revision and decides whether that auction is valid or not. If the state decides that that auction is invalid, it should not have been done, then there is the doors are open for us to seek state, my lords, in several such other cases, because there are more than 500-600 employees who have not been paid their arrears of rent, my lords, arrears of salary and benefits, my lord, from last 2 decades. For them, my lords, a scheme can be made. Government can give money, taking that property as a security. You know, that option is open for us. My lords, state, my lords, we have given representation. There are several such examples in state. State can, before the learner single judge, our petition was to consider a representation. In that we have sought for, my lords, that state should interfere in this matter and provide financial facility to the factory, and in turn our some arrears can be paid. Learner single judge asked to consider those representations in accordance with law. Then, my lords, my lords, if I can persuade your lordship to see the application, my lords, yes, I have filed it today, my lords. It has come, my lords. It is there in the file. It is there. In pleading and both are together, my lords. Adala ide, ಎರಡು ಇದೆ ಅದರೊಳಗೆ. ಅಲ್ಲ ಹಿಂಗಡೆ ಇದೆಯಲ್ಲ ಅದು, that is the one. ಅಲ್ಲ, yes, my lords, with that separate index is also there.
Second,
Many other applications.
Only 2 applications. 2 applications. I'm sorry, my lord, sir.
So everyone you have got it?
Yes, my lord. So have served. State also have served, my lord.
Having
State ಕೊಟ್ಟಿದ್ದೀನಿ, acknowledgement ಇದೆ.
sorry.
I think,
In that, my lords, your lordship may kindly see page page 24 to 45. Page 35 may kindly be seen, my lord. It is the translation of the endorsement issued by them. ನಿಮಿಷ ಕೊಡ್ತೀನಿ ನಾ ಒಂದು ಸ್ಟೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್.
What was the petition filed on wages only?
Yes.
This petition
Yes.
on wages?
Yes. That writ petition order, my lords, is there, my lords. Lordship will get it. My lords, annexure even page 15, my lords. Order starts at page 18, my lords.
Yes, then after that, what happened?
After that, my lords, we moved a contempt, my lords. In that contempt, my lords, they filed annexure A3 endorsement and a complaints affidavit, my lord. That typed, the translation of that starts at 35, my lords. The relevant portion, my lords, is at page, my lords, 43, para 8, my lords. Page 44, my lords, if lordship sees, fifth line from the top, the interim order passed by the Honorable High Court of Karnataka in WP 9000/2020, stay is granted to the report submitted by the Lokayukta dated so and so. And then, my lords, for that, they are not in a position to consider our request as of now is what they say. Then the next order, my lords, the very next order also produced, my lords. Sorry, my lords, that is in vernacular. I will translation of that also, my lords. I will give, my lords. At page 47, my lords, it says that because of that, they are not considering.
Actually, you have not go to the learner signature. Based on this.
Yes, my lords. My lords, one thing is that we can challenge that endorsement, my lords. But since, my lords, there is a possibility that, my lord, the learner single judge may say that since the division bench is seized of the matter and there is stay, we cannot act, my lords. We thought it appropriate that we seek this honorable court's indulgence. My lord, my prayer may kindly be seen, my lords. I have not come in the way of the petitioner's contentions also. Petitioner's contention is different from our contention in the sense, my lords, he is aggrieved by actions initiated against him because of the 12-1 report.
Your grievance was only with regard to payments.
Yes.
Salary. Yes. That's all.
That's all.
The representation.
Yes.
Where is the question of stay having a bearing in so far as the salaries are concerned?
My lords, I would say that that should not have a bearing, but the government is saying so.
See your prayer now in this application.
Yes. May I read, my lords? Wherefore, the applicant most humbly prays that this honorable court may be pleased to clarify that the interim order dated 6/8/2020 extended subsequently will not come in the way of state passing any order on the validity of auction.
Is this an issue? Was this an issue? The issue was only wages.
No, my lords. What happens is that, my lords, my humble submission is this. The state, my lords, the property of the factory. Yes, my lords.
Yes, you can now read further.
Yes, my lord. Yes.
With respect to
Validity otherwise of the and on any steps taken by state authorities to pay the arrears of salary and other things. My lords, the problem is this, my lords. There are in several past examples, my lords. State has done this where any such factory, my lords, goes into loss. Then, my lords, if there is a yes, our case is wages, but my lords, here the problem is that, my lords, the property comes in the picture because against the security of the property, my lords, the state would fund. I'm not concerned about that. Yes, my only worry is that state taking this as a shelter. The second order, my lords. The second order, my lords. Your lordship may kindly see page 47, the operative portion, my lords, translation I have just provided, my lords. They have said that our representations cannot be considered in the light of this writ petition and the interim order, my lords. Actually. 6/8/2020.
For the application,
Yes,
the applications to the,
given.
what you got it? Yes. You have seen the application?
Yes.
What is your take?
But I would not, payment of salaries to employees. I have no say. I will, I think it should be if they're entitled, if it is not paid, then they have, at least their representation has to be considered.
Which clarification which is sought, which is they are seeking?
But interim order should not come in the way of the consideration of their representation before the government. But the interim order is in relation. The interim order is in relation to the implementation of the recommendations. That is the interim order. But the non-payment of salaries are much prior to any of these proceedings. So it should not come in the way of the consideration of their representation if it is
The
before.
order will not come in the way.
Yes, my lord.
For
Sure.
the
Yes.
consideration of the representative.
Yes, yes. Because misfeasance, misconduct within the society is not the subject matter of this writ petition or any other petition. But if somebody is not holding up payment of salary on the ground that there is this writ petition or the interim order.
Yes, what is your?
And that only I have received, just now I received copies, my lord. I have to seek instructions, my lord, regarding this. We have filed an application for vacating of interim order much prior to it only. All further proceedings was stayed, my lord. For the reason only they would have taken that decision, my lord. I have to take secure instructions, my lord.
Proceeding in the crime number. For the proceeding in the crime number. That has been stayed.
I'll seek clarification.
What clarification you do?
From, no, my lord, annexures also not given to.
We have given entire set, my lords. Now they are coming and they acknowledge in the copy also, my lords. Take this. Yes, my lords, I have given.
Number 5.
Yes.
And may I just clarify, ma'am? It says interim stay of report dated 1st March 2018, passed under 12(1), and also further proceedings in crime number. Your lordships are, so both report and the crime number.
Not go before the learner single judge.
Lords, I have not gone it.
So you must go.
Yes, my lord.
Something which, yes, and so.
No, my humble.
Everything
Yes.
arises from there.
Yes. The learner single judge, my lords, are directed to consider our representation only. I may have to go now. I may have, plus my humble submission is this, my lord. I may have to challenge those endorsements before the learned single judge once again, my lords. That is another avenue that I have. But, my lords, even then, my lords, my humble submission would be this, my lord. Even learned single judge may say that when the learned, the division bench has stayed the my lords, 12-1 report itself, and the suspicion regarding or otherwise of the auction is also a subject matter referred to in 12-1 report, my lords, then it may, judicial propriety may not permit me to pass any order. You may have to wait that. My humble, I may be wrong, my lord, but my humble submission is that's what made me, my lord, to approach this honorable court and seek a clarification. I have to, in whole, my lord, I cannot challenge that endorsement before this bench, my lord. I may have to go before the learned single judge.
This day after get the CD application. This meetings.
Instructions on that, let the matter may go on.
Yeah. I'm just telling.
This petitioner has to renew this certificate. Complain. If these will be clear. If these two are permission and also.
Yes, Mr. Let's hear you.
Very well.
My lords, only on this one small point, my lords, before my lords, the judgment which my learned friend was relying upon, this Narsappa was also a petitioner there, which shows that this is actually a grievance. He was petitioner number 8 before the learned single judge, even in that judgment, which directly supports my case that it is actually all in the nature of a grievance. He's not produced that full judgment on because there were 268 people. Narsappa was directly there and he maintains the complaint. We just saw it online. No. My lords, in this impleading application that he filed, my lords, in this impleading application that he files, my lords, the judgment at page 15, my lords may kindly see the judgment at page 15, 98, my lords, petitioner number 98 is Narsappa. It's not there. The full thing is not shown, which would directly support my case that it is a grievance.
Believe the complete, memo.
Lords, that cost title part, Lords, I think is missed. Sorry, Lords. I'm sorry, Lords. I will, at the same thing as it was produced, I will make available the entire check.
Where are your representations?
Lords, my representations have not produced, Lords. I have it, Lords. They are in Kannada, Lords. I will produce the entire thing, Lord, by day after tomorrow. I'll make available. Sorry, just filed in a hurry, Lords. Extremely sorry.
We give you back.
No, Lords.
And to commence, Lord, I would like to, Lord, commend my learned friend.
Yes.
My learned friend for having prepared such a good, Lord, brief synopsis of the provisions and also, Lord, scheme of the act, this Roman 2, Lord, of my learned friend's submission. Lord, I am entirely with that. There is no doubt, no cavil, Lord, on that. Any of these parts. Item number 2, Roman 2. Brief submission which my learned friend submitted today. Roman 2, Lord, no cavil of doubt. Contentions, Lord, insofar as the judgments are there, Lord, that I will just try to point out that which judgment is applicable and which judgment would not. Not more or less in the facts of this case, what my lords would say, my lord, as judgment of this honorable court, would my lord, in my respectful submission, whatever little research I have done on 12.193 vis-a-vis 12.1, that would be the judgment on the point. There is no judgment independent in relation to 12.1 and the manner in which the complaint has been dealt with in this case by the honorable Uplokat. There is absolutely not a single judgment in spite of all the what my learned friend has submitted and what with my lord's permission I will submit.
Submission on this section
8.1b, yes. Lord, whether, yes.
Let's go in Syria.
Yes, Lord. Seriatim, Lord, even before that, Lord, may I request, Lord, to take the statement of objections of Lord, the respondent, complainant, respond number 6 and 7. Only one moment, one paragraph from that statement of objections, I'll just point out. Annexure R5 of the statement of objections filed by the complainant. Complainant, he has filed it on 6 and 7. He has filed it on 23rd February 2022. But my learned friend was able to point out to my lord's, he was able to bring to my lord's attention that there are several writ petitions, several proceedings pending in relation to arising out of more or less same cause of action, is what my learned friend was able to point out. Then, Lord, this statement of objections which my learned friend has filed for the complainant, Annexure R5, Lord, at page 27, is another writ petition. Annexure R5 at page 27 is another writ petition where, Lord, the petitioners, this is a PIL writ petition, where the petitioners were also members of the society, where your lordship will see respondent number 3 and 4. Your lordship, sir. Annexure R5.
Statement of
Your lordship, sir. Annexure R5, my lord, page 27. That petition, this is a PIL writ petition filed by 2 of the members of the same society. R3 and R4, your lordship will see are the petitioners before this, in this writ petition, who are parties there by virtue of their designation. Your lordship will see the prayer part 28 down below. These writ petitions are filed under Article 226, 227 Constitution, praying to quash the sale proceedings by Annexure G dated 27/1/2017, conducted by the sale officer. Same auction proceedings. Your lordship may kindly see the order. At this stage, we are not going into issue of locus of the petitioner to file the present writ petition. However, it is an admitted position that the sale proceedings on basis of 27(1) is not yet confirmed. Moreover, in a revision petition, filed by the fifth respondent, the auction sale proceedings dated 27 January have been stayed by the state government. The said order admittedly continues to operate even as of today. Therefore, there is no reason to entertain the writ petitions at this stage. We make it clear that the government will have to take an appropriate decision on the recommendation of Lokayukta in accordance with law. So, my lord, even apparently, my lord, the recommendations, the report which is subject matter of this writ petition, apparently, my lord, that was also, my lord, placed for the consideration of this honorable court in this writ petition. And this honorable court has said, my lord, that the government will have to take appropriate decision. I'll stop at. Yes, ma'am. We send it to the state government. In any case, we send it to the state government. Thereafter, state government will send it to the appropriate concerned authority. In this case, not the registrar of cooperative societies. It has been sent to the registrar of cooperatives. And I would say, my lord, if I can. Yes. And the next paragraph, my lord, is even more interesting in the same order. The next paragraph. Next, it is on the next page, my lord. Hence, in view of what is stated above and subject to the above direction, at this stage, it is not necessary to entertain this. So, my lord, this honorable court has already directed the state government to consider the recommendations made. My lord, that is what, that is the stage of it.
Order is dated
2019.
And the stay order is?
But this is 20, after this writ petition was filed.
Oh.
Without bringing, Lord, this, I think this writ petition is not referred in this writ petition which is before my lords.
The petitioners, you see that it is being tested, no?
Yeah, yes, my lord, but it should have been brought to, yes, my lord. Lord, for,
Only party.
yes, my lord, respond number 3 and 4.
Only 4, my lord. He was right. my lord.
Respond number 3 and 4.
Respondent number 3 is.
Respond number 3 and 4 are the petitioners.
I was a party, my lord. 4 is served, not represented. 4 is.
On the strength of it, that the state government has the authority to pass an order.
No, take it further. Take it further. That is all. Not all that I am trying to canvass is. Not all that I am trying to canvass is that it is a recommendation. It is a report. Not I will come to, I'll submit in relation to all each of the judgments which my learned has cited. 8.1b, yes, ma'am, that also I'll submit. So, my lord, this is the position of the 12-1 report as on today, 2019. This honorable court, I would not say the coordinate bench or, but I would say this honorable court has already directed the state government to consider the report, and subject to that direction, not this writ petition is disposed of, this PIL is disposed of. Not in para 2, not their lordships would say, we make it clear state government will have to take appropriate decision on the recommendation of the Lokayukta in accordance with law. That is para 2. Para 3 says, hence in view of what is stated above and subject to the above direction. At this stage, it is not necessary to entertain this resolution. There is only direction in this order is for the state government to take an appropriate decision in relation to the 12-1 report. So that is on the facts of the case. So I'll leave it at that, without, I would say, but I would say, without disclosing about that writ petition, this writ petition has filed and he has not come to court with, I will not even go into any of those submissions. I will not make those submissions because I have not stated them in my objections. It was not brought to my notice by my lord friend for the respond number 6 and 7. I had to bring that to my lord's attention also. So section 8(1)(b), grievance, what kind of a grievance, whether it is really a bar.
So are you saying this order of the
Yes.
They made a direction for the state government to consider it?
Yes, it is already there.
Oh.
But coming to the 8(1)(b) bar, that it has been read over, understood in different ways, in different manner, in different judgments, that I also look at it a little differently, which I will submit to my lords. 8(1), except as hereinafter provided, Lokayukta shall not conduct any investigation under this act in the case of a complaint involving a grievance in respect of any action. I'll read it again. Except as hereinafter provided, the Lokayukta, Upalokayukta shall not conduct any investigation under this act in the case of a complaint involving a grievance in respect of any action. B, if the complainant has or had any remedy by way of appeal, revision, review, or other proceedings before any tribunal, court, officer, or other authority, and has not availed of the same. So there are two parts in clause B. There must be a remedy, as your lordships repeatedly put it to my learned friend, and it should not have been availed. But there is a conjunction. There are two separate parts in that subclause B. There is a conjunction. The second requirement is that it should not have been availed on the date of, on the date of filing of the complaint or otherwise. The moment it is availed, then it does not remain as a bar or as a prohibition, this 8(1)(b). If a revision remedy is availed, or an appeal remedy, or any remedy, or a civil suit, anything, if any of that is availed, this 8(1)(b) does not continue to be a bar. It is a bar only insofar as the remedy is there, one, and it is not availed. The moment the complainant avails that remedy, the bar is extinguished. Otherwise, that bar could be there for investigation. And my lord, again and again, put this question to my friend, 8(1)(b), once that threshold 8(1)(b) is crossed, whether 9(3) there is a bar. But my answer is 8(1)(b) applies if there is an investigation. 9(3) applies also if there is an investigation. In the instant case, we have not conducted investigation. We have not called upon anybody to give their comments. We have not called upon anybody to submit their reply to any show cause notice. We have not issued any notice to anybody. We received a complaint. We thought it fit, the Honorable Upalokayukta thought it fit to conduct a preliminary inquiry by employing his powers under section 10 and 11 And my lord, two of the officers, one deputy commissioner and one SP of the district, they would find out. Yes, my lord, I've heard.
Let's see what
Yes.
steps you have taken.
But in relation to my lord, the question of grievance, but we have relied on a division, coordinate bench judgment of this on. Yes. Yes.
See the internal page 3 foot, my lords. 3 foot. My lords, the internal page 3 of their objections, statement over 2 and 3. My lords, it begins with statement of objections on behalf of respondent 2 and 3.
Yes, 2 and 3.
Yes. Yes, read.
Not- Yes, my lord. Para 6 may I read?
First,
Very well. The petitioner sought
okay.
well, the relevant to my lord's question, lord, would be para 6 onwards.
Para 5, page 3 foot would be relevant, my lords. 3 foot,
Yadu?
page 3 foot, sir. Last one is page 3.
6.
Yes, ma'am. It is submitted that this institution report under section 12(1), the lordships have it. It is submitted that this institution report under section 12(1) of the KL Act is also binding as per the directions to order passed by the division bench of this honorable court in writ petition number 10557558, which reads as follows. Para 2 and 3, not, which is what I read, not from my learned friend's objections. Para 2 and 3. Therefore, it is submitted that the orders are in accordance with rule and does not suffer from any illegality. Therefore, the impugned order is not liable to be quashed. It is submitted that the above order copy produced annexure 1. Regarding para 36, 37, so and so, it is incorrect to aver that it is submitted that the remedy provided under the Karnataka Cooperative Societies Act 1959 and rules framed thereunder to initiate civil or penal action against the petitioner does not bar for the disciplinary authority to take recourse to disciplinary proceedings under KCS CCA rules. It is also submitted that the Cooperative Societies Act 1959 is a step to ensuring proper management of the cooperative institutions as also for effective action on erring cooperative societies, whereas the report forwarded to take action against the petitioners is based on Karnataka Lokayukta Act 1984, which is enacted for the purpose of improving the standards of public administration by looking into complaints against administrative actions, including case of corruption, favoritism, and official indiscipline in administration machinery. Therefore, viewed from any angle, the intention of both the acts is independent to each other. As per section 108, powers of revision of the state government, that is extracted note, subject to the provisions of 108A, state government. Next paragraph, the above section makes it clear that in case of the order of the officer is contrary to law and has resulted in a miscarriage of justice, pass such orders thereon as the state government deems just. Apart from this provision, there is no provision which empowers either the Cooperative Societies Act to decide about the necessity or otherwise of the initiation of disciplinary proceedings. Therefore, the petitioner cannot take aid of provision under section 108 of the Cooperative Societies Act, hence the same is misconceived. Then not regarding the other parts.
What do you say here?
The remedy under 108 regarding revision and the complaint filed not for the purpose of consideration not of the misconduct committed by any of the respondents or notices therein. But that is entirely different. Revision, my lord, is for the purpose of setting aside of the sale proceedings, auction proceedings. And the complaint, my lord, the Honorable Upalokayukta or Lokayukta, even if they come to the conclusion that there is misconduct, that there is misfeasance in relation to the auction proceedings, they cannot direct, my lord, to annul the, because they will not conduct any inquiry as a registrar of cooperative societies, or, my lord, they will not conduct a case as a civil suit, or, my lord, they will not exercise any of the other jurisdiction. The only jurisdiction that they will entertain is in relation to action, which my learned friend read out, grievance or allegation. And in the light of those action, grievance, allegation, maladministration, if there is any misconduct, that will be not found out in the consideration, either through preliminary inquiry or in the investigation. So, my lord, the remedy under 108 is for setting aside the auction proceedings, which is not the complaint which is given by the complainant to the Honorable Upalokayukta. So, my lord, that is not an alternate remedy. 8(1)(b) will also not apply in those situations in a complaint, because it is not for the purpose of not setting aside of the auction proceedings. Then, my lord, next paragraph, para 8. It is incorrect to contend that the action of respondent number 2, Honorable Upalokayukta, and the resultant inquiry report dated 1/3/2018 under section 12 of the Lokayukta is bad in law due to violation of principles of natural justice, and in particular, the non-compliance of the procedures established under 9(3) of the Lokayukta Act. It is submitted that on the basis of complaint, Honorable Upalokayukta directed to the Deputy Commissioner, Davangere, and Superintendent of Police, Karnataka Lokayukta, Davangere, to conduct a joint investigation on the complaint and submit a report. The investigation officers have submitted joint investigation report and certain documents. On perusal of document form number 6. What?
We say investigation.
They are called as investigation officer. That term could be, yes, that term could be not loosely used most of the times. In all the judgments also, your lordship will see, always use the word investigation.
Fact finding.
Fact finding. Preliminary, again, preliminary fact finding. The moment we issue notice, it becomes more or less an adversarial, because the Honorable Lokayukta and the Upalokayukta are considered to be conducting quasi-judicial proceedings. So, there are.
Yes.
The investigation officers have submitted joint investigation report and certain documents. On perusal of document form number 6, dated 8/11/2016, it reveals that 188.58 acres of land, several buildings, sugar plant, workshop, machinery, boiler and refractors, every weight scales, gobar gas plant, continuous centrifuges, furniture, computer printer and typing machines were included in the auction sale. However, on perusal of the auction sale proceedings dated 27/1/2017, it indicates that the market value of the immovable property is 69 crores and value of the plant and machinery is ₹7 crores. In the auction notice, the market value of the property proposed for auction is not disclosed. The important aspects to be noted in this auction sale is that the auction sale was confirmed in favor of so and so. As per the documents produced, the Sangha, the said Sangha came into existence on 10/1/2017. The auction sale took place on 27/1/2017. On perusal of same, it discloses that the association, which was a successful bidder in the auction sale, came into existence 17 days prior to the date of auction sale. The report of investigation officers discloses that so-and-so obtained a loan of ₹8 crores from MLA Davangere for payment of initial amount in respect of auction sale. The said fact discloses that as on the date of auction sale, the so-and-so had no enough money to purchase the assets of the sugar factory in auction sale. The said fact indicates that the so-and-so was formed by some persons with an intention to make unlawful gain by participating in auction sale and by being successful bidder for lower amount than the actual worth of the assets of the sugar factory. It is also forthcoming that so-and-so collected a sum of ₹2 crores 73 lakhs by way of membership fee for repayment of loan, but it is not forthcoming as to what is the source of income for ₹so-and-so, which is repaid. No document is produced by the so-and-so in respect of the same. It is also pertinent that there were no records to show how rupees 2 crore 73 lakhs was collected, what is the amount of membership fee, and who are the persons who paid the membership fee. The above aspects go to show that the formation of the society is an afterthought. The involvement of persons who engage in money laundering in formation of so and so cannot be ruled out. Therefore, on the basis of joint investigation report, the Honorable Uplok Ayuktha exercising powers under section 12(1) of forwarded report to the competent authority to take action against the petitioners. Hence, it is submitted that while during the preliminary inquiry, there is no requirement of seeking comment from the petitioners as provided under section 9(3), where the Lokayukta Uplok Ayuktha proposes after making such preliminary inquiry, as he deemed fit to conduct any investigation under this act. Therefore, the above section makes clear that it is only after preliminary inquiry where the Lokayukta or Uplok Ayuktha proposes further investigation, forward a copy of the complaint or calling comment from the petitioner. It is also worthwhile to mention that after forwarding report under section 12(1), when the competent authority has then issued show cause notice to the petitioners dated 16/5/2019, Annexure Q, it is submitted that the orders are in accordance with rule and does not suffer from any illegality. It is totally incorrect to aver that since no material was placed on record to show that report under section 12(4) formulated, and even if the said report was produced, the same being without examination, state government, the whole process would stand vitiated. It is submitted that so and so. Then what our main contention is that we have conducted only preliminary inquiry, more or less a fact finding in relation to the complaint that was received, and thereafter submitted report to the competent authority. Thereafter, your lordship would see the annexures, subsequent annexures which my land friend producers along with the petition, show cause notices are issued. Even this to the petitioners, and there is a gap of about by the competent authority, respective competent authority. One by the Registrar of Cooperative Societies, Annexure Q, to the first petitioner, and the other by the Davangere District Cooperative Bank itself to the second petitioner. Annexure U. So, what I am respectfully submitting is what we have as submitted as a report under section 12(1) is only a preliminary inquiry report. We have not pinpointed any one person for having 1 or 2 persons for having done any misdoings, but for the simple reason that the findings of the preliminary inquiry have not come forward with more questions than the initial questions that were put to them. They say, the source of money is not known. They say, that how this society was formed, the successful bidder was formed is not known. The successful bidder is only 17 days old. How the successful bidder could have raised so much money, is again 66 lakhs is sought to be paid in relation to the 54 lakhs is sought to be paid in relation to the successful bid. So how that money could have been raised, all those questions have to be answered is what the inquiry report would say. This is not a conclusion of anything, this 12(1) report. It does not conclude anything. It does not name anybody. Of course, the complaint is in relation to two designated named officials. The complaint also does not name the petitioners by name. It's only so the recommendations are made in the manner that they are made. Again, if we were to do further dissection of the terms used in the act, I would respectfully submit we are not even at the stage of 8(1)(b), because 8(1)(b) also requires to be considered whether it is applicable or not only at the stage of investigation. If the Honorable Lokayukta or Uplok Ayuktha decides to conduct the investigation, he will consider whether it is hit by 8(1)(b) or not. Going back and forth on the in relation to the term investigation and preliminary inquiry, but both the terms are not defined here.
What about 9?
9(3), we are not at that stage is my respectful submission. Again, 9(3), what it requires is where the Lokayukta or Uplok Ayuktha proposes after making such preliminary inquiry as he deemed fit to conduct any investigation under this act. After making preliminary inquiry, if it is decided that we need to do more investigation under this act, then it is required not to give notice, to call for comments, to give copy of complaint, to give copy of that joint investigation report. Everything should have been forwarded to the notices. Whoever would have been the notices or the respondents there, it should have been sent to them in compliance with 9.3. That is not the purport of 9.3. 9.3 comes into play only if the Lokayukta or Uplokayukta decides to conduct investigation under the act. If they only do preliminary inquiry, or as my learned friend was also not has also succinctly pointed out, if they decide to close the case, they have to close the case, inform the public servant, inform the complainant, inform the competent authority. We do not decide to close the case. It is for us to not make a recommendation of the nature that has been made here also. Yes, ma'am. That is the purport of not section 9, whole of section 9. Not the also the object of conducting preliminary inquiry, as my learned friend also made a submission in passing, that there could be my instructions also are for a different case. I sought for that statistics. My instruction about 3,000 complaints are received in a month. 2,500 plus complaints are disposed of not at the preliminary stage, at the scrutiny stage. So, a preliminary inquiry is required and it is conducted in almost all the cases. I could not say that in all cases. I could not say that in most cases. So that numbers I do not have right now. But there are cases, complaints are received, and all of us today are aware that most the so-called RTI activists, all of them who come before by filing this, most of these complaints in form number 1 and 2, it has to be scrutinized for verification of the veracity, because the moment a notice is issued to a public servant, other things follow, the consequences follow. So the Honorable Lokayukta, Uplokayukta, they are aware of those. That's why the process has been established since 86 itself when the act was enacted. So there is a scrutiny conducted, there is a preliminary inquiry conducted, and thereafter a decision is taken to take the next steps. In the instant case, after the preliminary inquiry, it has been decided to refer the entire matter to the state government, to the competent authority, with the 3 recommendations only. And your lordships have also observed, in none of those recommendations are we saying initiate police action, initiate criminal action. We are not saying that. Though, there is a judgment of coordinate bench of this Honorable Court which would say in the 12.1, 12.3 report, we can also recommend for initiating criminal prosecution, criminal action, investigation also. So, for the kind of preliminary findings which have fact finding, yes, it could be. But again, dissecting more and more deeper, because 12.1, my learned friend pointed out, it uses the term investigation. Only after investigation you give 12.1 report is what my learned friend is contending. So if you look at that, yes, there is an issue that I am faced with. There is a wall that I am faced with. 12.1 says, if after making investigation, you give your recommendation. 12.3 also says, if after making investigation, you give your recommendation. So that wall is there. May I read? Because we are making some recommendations which are in the nature of taking corrective steps. Yes. Yes.
What should have been the manner in which the final direction was?
But in the same, more or less in the same nature. But it would have named the officials.
But you would have named
officials, yes. You would have named the officials clearly and succinctly.
You have left it to the state government.
Yes.
there had been an investigation, you would not have given the report in the manner you have done.
Lord, we would have, probably it would have been more clearer, not more details. It would have been specifying the names, not further details. This is a 3-page report, Lord. I would assure my lords, if we had conducted, Lord, it would have run into at least 40, 50 pages. The recommendation itself. We have only, my lord, investigation report we have referred to, the preliminary inquiry conducted by 2 officers, the deputy commissioner and we have only referred, my lord, we have picked up few numbers from there and put it in this report and sent it to, my lord. Otherwise, if we had conducted, we would have made a further details would have been available, documents would have been referred to.
Ultimately, what is being said is agreements of the complainant can be
Investigated.
investigated.
We have not reached that stage, is my respectful submission. But your lordship may kindly see, I will also, my lord, try to, my lord, impress upon my lord to submit this with respect. Lord, the complaint is received. Lord, all of us are now aware that there are innumerable proceedings in relation to the 27/1/2017. It has, Lord, spread its tentacles everywhere, looks like, in the form of revision petitions, my lord, allowed, sent back, dismissed, sent back, approaching this on court, sent back. So revision petition itself, my land friend would confirm if I am not wrong, 4 times, my lord, it has been disposed of and sent back to the revision authority. And even once. Lord, I think against the interim order disposal, so multiple, not fact remains, but there are several writ petitions. I'll stand corrected. If it is one, it's only one, but writ petition numbers are at least half a dozen of them. Then, Lord, what the Honorable Uplok Ayuktha probably in his mind would have, applying his mind would have thought of, more detailed inquiry, investigation, everything is required. So, my lord, and the moment a complaint is received, we cannot just close it and say 8(1)B, go there, go here and all. We could have said, close it at 8(1)B and said, go to the revision petition if it is available, and then that could have also been done. But, my lord, the manner of the kind of, my lord, the misconduct which has been complaint which has been received, my lord, that required some kind of preliminary inquiry, which we have conducted. And I would respectfully again repeatedly, my lord, submit to my lords, I would urge my lords to consider my submission that it is only, my lord, a preliminary fact-finding report which has been submitted to the competent authority, which requires further investigation, which requires further action. It does not end there. It does not, my lord, prosecute my learned friend immediately. But again, before prosecution, there has to be an investigation. What we are saying is investigate. What we are saying is not go and prosecute. Even not registration of FIR, not will immediately thereafter, not what comes is the investigation only, not prosecution. So the FIR registration also, not in my respectful submission, contrary to not what my learned friend would seek to canvass before my lords, is required in the nature of facts, not assuming they are innocent, even assuming they are innocent. Even not your lordship could say in the FIR, name of these two petitioners can be removed, but the investigation is still required not for what is there, the bundle of facts which has come to not to the notice of all of us, not as officers of the court, that the bundle of facts which has come to my lord's attention also. Your lordship will not just rubbish it or throw it away on some technicalities. And I do not want to be seen as a person, not under instructions I would submit, that not following principles of natural justice. Your lordship would say, we have not followed principles of natural justice, not send it back, not we'll issue notice once again, we'll conduct the proceedings. Absolutely no, not second thoughts about it. But whether that natural justice requirement was there in this situation, and what has the report not resulted in relation to the petitioners. Not after the report, 1/3/2018 report, not after that for more than 2 years, nothing has happened. Not I am only assuming the Registrar of Cooperative Societies or the state government not were internally discussing what is to be done, and it has not resulted in the show cause notice in June of 2020. That is 2 years, 1 quarter later. Slightest of doubt that your lordships have in your lordship's mind, Lord, kindly send it back. No, we'll issue notice. No, absolutely no doubt about it. We'll issue notice, we'll redo the whole thing.
Yes.
Not, we do not want to be seen as not following principles of natural justice. Not, it is not both Honorable Lokayukta and Honorable Lokayukta, not by their stature, would not want to be seen as not having followed principles of natural justice. Then not coming to the judgments, may I just answer those judgments? Not this is, looks like a heavy compilation, but I'm not, I'll just touch upon each of those judgments which my learned friend has. Only one of them is for me, not important. But totally about 300 pages, but 2 of them are running into almost 200 pages. Rest of them are not that, not for, that is the item number 11 and item number 6.
Let's see.
Let
us see 6.
Yes, 6 is not the Professor S.N. Hegde judgment, which is referred to in several other judgments also. Even though not 6 runs into about 75 pages, the only required paragraph is para 91 in that judgment.
Let's see.
91 of, I'll just take relevant page. Yes. Referred, followed.
Let's see.
But Gundappa has not been overruled by nobody. No one has. Yes, yes. Yes.
But this is the division bench Gundappa.
That's right. Say state of Karnataka.
Lordship could start from page 100. No? Page 100. Para 78 regarding point E, whether the procedure prescribed under section 9 is mandatory. Lord, this is Lord, Professor S.N. Hegde, the petitioner, Lord, he is a professor of the Mysore University. Lord, against him, Lord, proceedings are initiated. Lord, whether the university comes, Lord, the professor of the university would fall under the definition of public servant was being considered. But this honorable court came to the conclusion that he is not. University is not one of the listed items under section 212. So, Lord, this honorable court would also, in this petition, consider the constitutionality of section 9. And his lordship would come to the conclusion that section 9 is constitutionally valid. Para 78 onwards, para 78 is this question, whether the procedure prescribed in section 9 is mandatory, arbitrary, I'm sorry. Para 78.
Yes.
So this is answered not to say that it is not arbitrary. While saying so, your lordship could also see para 80, A.K. Kraipak's case is referred. Not why I would also point out A.K. Kraipak's case is natural justice is not just an empty formality. The line of judgments, A.K. Kraipak's case, Jesus Sales Corporation, not all of them would say, if statute says natural justice, follow natural justice as per statute. If statute does not say natural justice, then natural justice has to be followed, mandatory. Has to be, I'm sorry, I stand corrected, has to be ready. Then Lord, para 81, section 9 is extracted. Then after discussion, Lord, of all the cases, para 89, investigate is defined, is interpreted. The term investigate is interpreted. I'll read 89, Lord. 21st century dictionary gives the meaning of the word investigate as to carry out a thorough, detailed, and often official inquiry into or examination of something or someone. Black's legal dictionary gives the meaning of the investigate as to inquire into a matter systematically to make a suspect the subject matter of criminal inquiry to make an official inquiry. That is investigate. So investigate not is to be understood as something little bit more than inquiry, preliminary inquiry. Then not para 90, Gundappa's judgment is referred. Para 91, division bench Gundappa is referred.
You did not involve anyone in this.
No, Milord. Not as an adversary, Milord. We only did fact finding. That also I'll point out, Milord, from one of the judgments here. Para 90, Gundappa, honorable single bench. Para 91, Milord, division bench Gundappa, not confirming the honorable single. Then para 92, a reading of section 9 of the act makes it clear that the legislature took care to insist upon the observations of principles of natural justice even before the Lokayukta decides to conduct an investigation under the act, making preliminary inquiry. If the intention was that without hearing the public servant, the Lokayukta should not embark upon an investigation and took care to specifically provide for the observance of principles of natural justice as contained in section 9.3, it cannot be said that after satisfying the aforesaid provision, the Lokayukta is under no obligation to follow principles of natural justice, while actually conducting an investigation into the complaint after the public servant offered his comments, denying the allegations made against him, the principles of natural justice and the necessities for its observance in any manner of investigation or inquiry is sine qua non of every judicial or quasi-judicial act. But I'll pause here for a moment. But this para 92 would have come to the aid of my learned friend's arguments, would still come to his argument, his aid. What this para 92 says, a reading of section 9 makes it clear that the legislature took care to insist upon the observation of principles of natural justice even before the Lokayukta decides to conduct an investigation under the act. But what this para 92 says, even before we decide to conduct investigation, you put him on notice, is what this 92 says. We have to put him on notice. Notice. Well, may I read again? I'm sorry, it was not clear. A reading of section 9 of the act makes it clear that the legislature took care to insist upon the observations of principles of natural justice even before the Lokayukta decided to conduct investigation. That we should have put him on notice even before investigation is decided. This is not the judgment of this Honorable Court. Again, Lord, this is again, in this case, in this instant case, the decision was in relation to a particular individual. A decision to conduct either investigation or preliminary inquiry was in relation to a particular individual, a named individual. In the light of this, Lord, and the judgment would go on to say, Lord, what happens if a notice is issued to any public servant or to any individual, the consequences, the fallout of such action, all those are not discussed in detail. But I will not trouble my lords with that. But my learned friend should have pointed out para 92, which I am pointing out to my lords. But this still not, I would respectfully submit that this does not debar or prohibit the kind of report that has been not submitted in the instant case. For the reason that it does not name any individual, it does not name any public servant for any purpose. And we do not say just go right away and prosecute him. We only say further investigation is required. Then Lord, again, subsequently, Lord, there are other judgments also. Lord, first of the judgments which in my compilation, Lords, my learned friend has already read. First one and second one. Lord, in the list of
the findings are from the report, whether impacting anyone. Just
is not fall foul of this judgment.
so hence the principle of natural justice need not be.
At the stage that this 12-1 report has been submitted. Yes, ma'am. Yes.
Yes.
Lord, your lordship may kindly take note the list itself of the judgments. Lord, these are all judgments, Lord, which also apart from deciding other factors, section 9 is not the caption, I would say, section 9 related judgments under the act in the list of judgments. Lord, first judgment number 1 and 2, Lord, your lordship are at the list.
Which one?
Lord, in the caption I have said, these judgments are only in this section. Yes. Then Lord, first judgment my learned friend has already read, N. Gundappa. Lord, second judgment is the Honorable Division Bench judgment confirming N. Gundappa's case. Lord, again, I'll pause here for a moment. N. Gundappa, section 7.1, 7.2, a public servant is named in the complaint. It is in the nature of a direct complaint, direct allegation against the public servant, that is N. Gundappa. But this Honorable Court came to conclusion that a copy of complaint, everything has to be submitted to him. His comments were required to be called. But on the same day of the judgment in N. Gundappa, but the same Honorable Judge, your lordship will see, page 1, N. Gundappa judgment rendered on 20th April and 19th May 1989. Your lordships are down below. Your lordship may kindly come to page 19. This judgment, Lord, your lordship will also see this is also dated 20th April 1989. That same day, these two judgments were rendered by Lord, Honorable Judge of this Honorable Court. That's Gundappa is in relation to 7172. This Chaudappa is in relation to 72A. Same day, Lord, this Honorable Court said in the other judgment in relation to 72A, 9.3 is not required. But, 7172, 9.3 is required. 72A, 9.3 is not required. So, Milord, there is a distinction drawn by this Honorable Court when it comes to what kind of situations that each of these complaints deal with. But 7172, complaint and suo motu action. 72A is referenced by the state government. State government to the Honorable Lokayukta or the Upalokayukta to conduct 7-2A. 7-2 to the Upalokayukta, complaint and Gundappa applies. 7-1-7-2 complaint and suo motu action, Gundappa applies. Follow 9-3. 7-2A reference by the state government to the Lokayukta or Upalokayukta, Chaudappa applies. 9-3 is not required to be followed. Not again going back to Jesus Sales Corporation and AK Cry Park. In spite of it, this honorable court said 9-3 not required. Then Lord Ranganarsaya, fourth judgment. Fourth judgment, Lord. That is page 28.
Yes.
That also says 9-3 is mandatory in relation to 7-1-7-2. This is in relation to section 14 prosecution proceedings. Ranganarsaya, not relevant, but 9-3A it says mandatory. Lord, Gundappa is 7-1-7-2, says 9-3 mandatory. Gundappa says 7-1-7-2, 9-3 mandatory. Same day, my lord, this honorable court rendered judgment in Chaudappa, 7-2A, 9-3 need not be followed.
Yes.
Ranganarsaya, section 14,
7-2A is
9-3 is not required. So Lord, when I say 9-3, I am using a short form for natural justice, issuing notice and calling for comments. Then Lord, section fourth judgment, Lord, section 14, 9-3 is mandatory. Prosecution. If I recommend that there has to be a prosecution, Lord, I have to, before that, I have to put the public servant on notice. That is fourth judgment. Ranganarsaya. Then Lord, fifth judgment, I'll request Lord permission to read 2 paragraphs from fifth judgment. This is directly on the point, more or less. Starts from page 36. I'll read para 4 and 5.
Yes, let's see this file.
Para 36, page 36. Matter arising out of Andhra Pradesh Lokayukta Act. Parimateria provisions, Lord. Section 10 was considered. Head note A, Lord, refers to section 10-11, preliminary verification and investigation procedure. Head note B, Lord, section 12-1 report, 12-3 report, interim report, recommending suspension or transfer of the government servant concerned. Head note C, my lord, refers to section 7-1, 7-2, 7-3. Now, my lord, this is what was laid down, Lord. May I request, my lord, to come to para 3 of the judgment. I'll skip para 1 and 2. Paragraph 3 of the judgment. subsections 1 and 2 of section 7 gives Lokayukta and Uplokayukta respectively to investigate into any action concerning persons respectively mentioned therein. Subsection 3 of section 7 enables Lokayukta, notwithstanding the power conferred under subsection 2 thereof on the Uplokayukta, to take suo motu action in respect of any action contemplated under the Act. Therefore, the only condition precedent required thereunder is to record reasons for initiating suo motu inquiry, divesting the power of the Uplokayukta and taking action under subsection 3 of section 7 of the Act. Hereon it is relevant, my lord. It is next contended that the petitioner has not been given any opportunity before submitting the report to the government, and the action is contrary to section 10 read with section 12 of the Act. We find no force in the contention. The Lokayukta is empowered under the Act to conduct such preliminary verification as he deems fit or proposes to conduct any investigation under the Act to find whether the allegation in the complaint prima facie justifies for conducting regular investigation. Subsection 2A of section 10 postulates that every preliminary verification referred to in subsection 1 shall be conducted in private, and in particular, the identity of the complainant and of the public servant affected by the said preliminary verification shall not be disclosed to the public or the press, whether before or during the preliminary verification. But every investigation referred to in subsection 1 shall be conducted in public. In other words, the statutory provision contemplates that while conducting preliminary verification of the complaint under subsection 1 of section 10, the investigation is required to be made in confidentiality and on satisfying from the investigation of the alleged misconduct, etc. He is empowered to take further action under the Act. He is also empowered under section 11 to collect evidence or have the investigation done as a civil court by operation of subsection 2 of section 11 of the Act only when he satisfies that there is evidence to proceed further under section 10(1)(b). At that stage, he shall afford an opportunity to the aggrieved person to comment on such complaint of this statement and conduct the investigation or inquiry. He is enjoined to give reasonable opportunity to the public servant. After conducting the said inquiry, if he finds that the public servant or the person referred committed misconduct, then he is required to submit the report to the government as enjoined under section 12 of the Act. On receipt thereof, under subsection 3, it shall be lawful for the government to take action as recommended by the Lokayukta. Considered from the operational conspectus of the above provisions, it would not be necessary to issue any notice after he comes to the conclusion that it is required, further investigation is required. Not at the preliminary stage. But that is the last 3 lines of this para 5 will come to that. But I'll read from at that stage. At that stage, he shall offer about 3 lines before that. At that stage, he is also empowered under section 11 to collect evidence or have investigation done as a civil court by operation of subsection 2 of section 11 of the Act only when he satisfies that there is evidence to proceed further under section 10(1)(b). Only when he is satisfied that he has to proceed further under section 10. At that stage, he shall offer an opportunity to the aggrieved person to comment on such complaint of the statement and conduct the investigation or inquiry. He is enjoined to give reasonable opportunity to the public servant. After conducting the said inquiry, if he finds that the public servant or the person referred committed misconduct, then he is required to submit report to the government as enjoined under section 12 of the Act. On receipt thereof under subsection 3, it shall be lawful for the government to take action as recommended by the Lokayukta. Yes.
So if something has come in the government, then we will hear it.
Yes.
Even as a preliminary inquiry.
Yes, it could be done. We do it day in and day out. But this case seems to be entirely different from what has been done in most of the other cases. In most of the other cases, we would have gone further, we would have investigated, we would have put him on notice, put the petitioners on notice, we would have called for comments, and if required, we would have sought for entrustment of conducting the inquiry by us, disciplinary inquiry by ourselves. All those could have been done. But here, not in the facts of this case, in the instant case, not in this writ petition, not the Honorable Uplokayukta, not in, by application of his mind, he has come to the conclusion in his discretion that not a recommendation of these actions to the competent authority is sufficient, is what I understand.
This sentence, that stage,
Yes, my lord. That stage contemplates, my lord, yes. Lord, at that stage, when there is an, at a stage when there is an aggrieved person named, a named person who, there is a prima facie misconduct, at that stage, my lord, you have to issue notices what this contemplates. Very good. May I, Lord, just 2 minutes complete this paragraph only. This paragraph only. Now, since we are at it, at this paragraph, I'm seeking indulgence. Lord. 2 minutes only. Considered from the operational conspectus of the above provisions, it would be necessary to issue notice to give or give an opportunity to public servant at preliminary verification or investigation. When the Lokayukta or Uplokayukta, as the case may be, conducts a regular investigation into complaint, it would be necessary to give prior opportunity to the public servant, etc. By implication, such an opportunity stands excluded when preliminary verification or investigation is conducted. The object appears to be that preliminary investigation or verification is required to be done in confidentiality to get prima facie evidence so that the needed evidence or material may not be got suppressed or destroyed. It is seen from the report submitted by the Lokayukta that he has prima facie found that there are some allegations against the petitioner. We are not dealing with the nature of the allegations since the matters are yet to be investigated. Suffice it to state that Lokayukta has power to submit a preliminary report to take further action so as to enable the Lokayukta to conduct further investigation. The power to submit final report with recommendation to take punitive or penal action includes power to submit interim report with recommendation to suspend an officer or to transfer him pending further investigation or the preliminary verification itself. The object of the recommendation is only to enable smooth inquiry or investigation conducted without being hampered with by the persons concerned or to prevent an opportunity to tamper with the record or to destroy the record. Under these circumstances, we think that the Lokayukta was well justified in not issuing notice to giving or giving an opportunity to the petitioner at preliminary verification.
HR Shauri, my name. Shauri, HR is my name. Applicant is one Mr. Dwaraknath, T. Dwaraknath. Yes, clerk. It's 30. Clarification of the 6/8/2020, order dated since page 12 of the yes.
Annexure, complete annexure, complete annexure.
Yes. Representation. Yeah, that both I will file along with the memo tomorrow itself. Tomorrow itself I'll file. Much.
Yeah. One more, our matter is also there.
Saturday, my lord. Subject to my lord's convenience, my lords, could, subject to my lordship's convenience, could we request for working Saturday, my lords?
already
I am, because Mr. Chidambaram's matter is also there. Two 230, 230, 230. Oh, wait. Well, the interim order needs to be extended. Great.
Just file it tomorrow. You file it in the registry, all those annexures, everything, representations in translations.
Yes.